Judgment of
Commencement of judgment, second petition.
There is no manner of doubt that the charge allegation against the petitioner is grave, wherein the aspect of loss to the state exchequer of a huge amount is involved. In fact, the amount has been quantified at rupees 28 lakh something, involving 15 numbers of deeds registered by the petitioner as the registering officer, wherein there were gross undervaluation of the properties involved. The contention raised on behalf of the petitioner that he was not aware of the communication dated 15/12/2003 issued by the Revenue Department on the aspect of valuation of properties in Greater Guwahati, and that the said communication is an inter-office communication and was not served in the office of the petitioner may not prima facie appear to be acceptable. The said communication was an existing communication for the last about 5 years when the deeds in question were registered. The petitioner, who was a sub-registrar at Guwahati at that point of time, and it being on record that he was posted in Guwahati in the year 2004, as stated in paragraph 2 of the writ petition, it appears unreasonable to feign ignorance of the said communication dated 5/12/2003. This court is also not inclined to accept the submission that no role was to be performed by the registration officer regarding valuation in terms of the letter of 28/11/2005. This court is also not inclined to accept the submission that there being a suo motu power of the collector under 27A3 of the Assam Amendment Act, that the charge is not liable to be leveled against the petitioner. Having observed that it is, however, required to be examined as to the manner how the disciplinary proceeding and the inquiry was initiated and held, this court, however, reminds itself that such examination by this court is on a prima facie aspect, as this court plays a secondary role in matters of disciplinary proceeding, wherein the primary role is of the disciplinary authority. Show cause notice dated so and so, and the statement of allegation mentioned 4 numbers of documents and 2 numbers of witnesses. The inquiry report submitted would reveal that while witness Pavitra Kumar Das had appeared and his statements were recorded, the other witness Vipin Goswami had refused to make any statement. Further, the inquiry officer has recorded that in the statement of the witness Pavitra Kumar Das, he had denied having any knowledge about the subject, as his work was on different aspects. The inquiry officer has in fact made the following observations so far as the aforesaid witness. Therefore, his statement is not of very essential in this case. That is the quotation. This court has also looked into the original records of the inquiry proceedings, inquiry produced, from which it revealed that the said witness Pavitra Kumar Das did not say anything towards the culpability of the petitioner qua the charges. It appears that the inquiry officer had come to a conclusion of establishment of the allegation only on the presumption that the petitioner was expected to have knowledge of the communication dated so and so. This court is of the view that such presumption could not have been drawn, as the categorical defense of the petitioner was that he was not aware of the said communication and the same was never served in the office. Even assuming that such defense was factually incorrect, the same was required to be prima facie established in the inquiry through witnesses who were named as observed, the same was not done. As regards the order of penalty, the disciplinary authorities appears to have proceeded on an entirely incorrect perspective with regard to the burden of proof. It has been held by the disciplinary authority court. It reveals from the inquiry report that the charged officer could not produce any evidence, documentary proof that he was not guilty in any way. The aforesaid approach of the disciplinary authority is contrary to the provision of law, as the burden of proof, though may not be in strict conformity with the Indian Evidence Act, has to be discharged by the department which has leveled the allegation against the delinquent officer, and there was a denial of the allegation by the said officer on record. A disciplinary proceeding cannot be culminated with an order of penalty only on the ground that such denial of the allegation is not acceptable. And in fact, it is only when the allegation is denied, the same is required to be proved in an inquiry. However, in the instant case, the same is not done at all in the inquiry held. In that view of the matter, impugned order has been set aside and he has been directed to give all the benefits since he is already retired from service.
Great.
Records are returned.
Great.
Yes, Mr. Chakraborty.
Item
No,
28.
I am for the petitioner, is for the respondent, item 28.
Yes.
It is a matter where record is required, there is an order. However, record is not available with the,
Record by the government.
my lord, FCI,
FCI, your lord.
Okay.
item 28.
19 matter. You are for the FCI.
I'm for it.
What record proceeding? Disciplinary proceeding?
Department, discipline.
But the records that we have not received the records yet, your lordship.
Why? Proceeding of which year?
My lord, 19, my lord,
19.
19.
19
In fact, my lord, the
It's a
record,
penalty order.
no, my lord, it's not a penalty. Before the penalty, there is a stay because the ground on which we have challenged is that the FCI could not have concluded the inquiry, common inquiry, and that too after my repatriation to my parents' part. I was an employee of Arunachal government on deputation to FCI. Now, after the
Now, yes, okay. When do you get the record? 19 matter, we are not supposed to adjourn matters of this nature. Yes, when can you get the records? Where did it come from?
Arunachal Pradesh, your lord. Itanar.
Oh. Have you asked for the records?
Yes, we have already asked for the
When?
records.
When?
in fact, records were called for
No,
as a
no.
last order.
No. When did they communicate? Court's order has to be communicated.
Your lordship, it was communicated on the same date, on 2nd of April, your lord.
Get the records. Yes, Mr. Chakraborty, suggest a date.
My lord, if it is otherwise not inconvenient, 20th of June, the Thursday, hearing day.
Today is, no, 1 month. Why 1 month? 19 matter. After 2 weeks, suggest a date. If records are not there, we'll proceed. We draw inference.
Thirteenth of June, my lord. That's part of.
What is your name?
D. Akram, your lord.
D. Akram.
Appearing on behalf of BKC.
Sri D. Akram, Learned Counsel, appearing on instruction of Sri BK Singh, Learned Counsel for the FCI. Praise for time on the ground that records are yet to be obtained. Full stop. Sri S. Chakraborty, Learned Counsel, is present for the petitioner. Full stop. The considering that this matter repetition is of the year 2019, a final opportunity of 2 weeks is granted to enable obtaining of records. Full stop. List for hearing on
13th, my lord, 13th of June.
13. Not 13. We will not give 1 month. We are giving 2 weeks. 1, 2. We'll give slightly more than 2 weeks. On 4th of June. 4th of June. Full stop. It is made clear that if records are not available, this court will proceed without the records. Yes.
My lord, I filed a IA, my lord, item number 17, my.
Yes.
I may be called for, my lord.
Yes, please.
Wait, Mr. Lordship,
Yes.
actually, with the consent of the other side, I beg to mention item numbers 13 and 14 of the daily list, Lordship.
Yes.
Lordship, the conducting council has some difficulty with the Lordship.
Here for the GMC.
Yes, Lordship.
You inform the other side.
Yes, Lordship.
I have put the item number 13, your lord.
And 14?
14, Lordship, you've informed.
Oh, it's connected.
Yes, Kaputi, Lord.
It's connected.
Yes, Lordship, both the matters are connected.
Okay. When do you want?
Lordship, after 2 weeks, sir.
On a prayer made on behalf of the GMC, of the respondent GMC, matters are adjourned to be listed after 2 weeks.
Lord.
Same order.
Problem.
Is there any interim order?
No.
No.
Okay. Okay.
Paid reason of it. They very wrongly drafted with petition matter that come from another member to people. I'll place the text matter on a very narrow campus matter. First, we kindly turn to page 16, paragraph 32. The basic grievance of the petitioner.
Just a minute, please. Yes,
Paragraph 32, my lord, page 16.
32,
My lord.
page
Page 16, my lord.
16.
My lord. My lord, in orders organization, my lord, the
BRO.
my lord, the subordinate engineers were earlier, my lord, three categories of employees were there under the subordinate engineer,
Now, why don't you tell us the basic facts? Then we come to 32.
my lord. My lord,
Who are you? How many of you are there?
petitioners are, my lord, 14%.
14 petitioners.
My lord.
They are what?
They are all junior engineers, my lord.
J in BRO.
BRO.
Okay. Then
Earlier, my lord, there were three groups under the junior engineers, my lord. First one, my lord, overseer, superintendent, my lord, superintendent grade 2
Hmm.
and superintendent grade 1.
all are junior engineers.
All are junior engineers. Subsequently, my lord, in terms of 5th CPC recommendation, all these three posts were merged. In terms of 5th CPC recommendation,
Just a
my lord,
minute, please. Then fifth pay commission, what has happened?
my lord, 5th CPC my lord, recommended for merging the three groups, my lord, into a single cadre, and it was renamed as junior engineer.
Hmm. When was it?
In 1996, my lord. 1996,
Hmm.
with paper
Accordingly merged.
merged, my lord.
You all became junior engineers.
All becomes junior engineer. What happened, my lord, in the BRO, as cadre reviews were not done at that point of time when this petition was filed, the junior engineers were stagnant for, my lord, around 32 years, 33 years. My lord. They had to work as junior engineers only, my lord,
Hmm.
without any promotion.
Hmm.
So, my lord, 5th CPC recommended for cadre review. Accordingly, my lord, cadre review has been done. But,
Hmm.
my lord, promotional avenues has been, my lord, made without, my lord, amending the rule. But in the other departments like CPW and, my lord, military engineering service, all the rules were, my lord, subsequently amended in terms of 5th CPC recommendation.
Hmm.
And they were given promotion, my lord, on the basis of seniority as well as, my lord, merit by giving a
Yes.
but in BRO, my lord, that has not been done. So the petitioners people of chief, they are praying for a direction to the authority for amending the rule in terms of PPC recommendation, as has been done in the other departments, as well as the, my lord, for creation of promotional avenues and for
Difficult prayer, Mr. Saikya,
yes,
but
yes, that I
Mr.
understand.
Chakapati, no, that is okay. He may not have a very strict, a very tight case for giving such a recommendation. But if you have given to other organizations similarly placed,
Yes, ma'am.
why do you leave out the BRO?
We have our own set of rule, Lord. In between, they want to abolish the post of assistant executive. In the hierarchy under the rule we have that. chance to have an assistant.
No,
engineer
is there a
facility.
promotional avenue for junior engineers?
Lordship.
Do you have?
Yes, Lord.
You have?
Under
They have, my lord.
Then
They have
there's no
malad-
or in
stagnation.
where the promotion is
Lord,
not
in-
even, we get the SCP and MSCP, Lord. That is.
In other departments, my lord, the junior engineers are promoted to the first, my lord, to the post of engineer, assistant engineer, my lord, assistant engineer. Then they are promoted to directly, my lord, executive engineer.
No, that is okay. That is like the state rules.
In-
But
in-
what is your qualification? Are you diploma holders or graduates?
but
Diploma
they are-
holders.
but
You
some
are
of
not
them-
graduates.
Some of them are, my lord, graduates also.
Now, what is the rule regarding if you are a graduate or you have attained the graduation?
My lord,
I mean the BE
my lord.
in the meantime.
Right.
Then what is the provision in the rules?
No, there is no rule, my lord. As such, my lord, the one of the person, my lord, this, my lord, I have filed a petition before this honorable court for him also, my lord, on Chandra Kumar. He was, my lord,
No,
MTech,
Mr. Saikya, just imagine a case situation.
my lord,
You are a junior engineer. You are a diploma holder.
diploma holder,
You entered the service as junior
my
engineer.
lord,
In the meantime, you, by following the due process and by taking permission, you also obtained the BE degree.
my lord.
You become a graduate and you are then entitled for a direct recruitment to the post of assistant engineer.
Right.
No problem with that.
Right.
But as a junior engineer, for the length of service which you have rendered, is there any concession? Like a junior engineer who has served this much period as a diploma holder who has served this much period as a junior engineer and in the meantime has attained the qualification of BE,
Right.
will he get any concession?
No. As per rule, my lord, they have no conflict. One of the person, my lord, what I am saying, my lord, yes, Chandra Kumar, he was MTech from IIT. He had to work as junior engineer for all along, my.
Now, why didn't he participate in the direct recruitment?
They did not allow us to participate.
Why?
They did not even allow us to participate.
No. If there is a direct recruitment process for the post of assistant engineer,
My lord.
which is open for a BE or a BTech, a graduate.
For that, my lord, we have to take NOC from the department.
Yes.
They do not give the NOC.
No, if you are refused an NOC, that is a different cause of action. We'll examine definitely. But here, as a matter of right, let us hear Mr. Chakraborty. What do you say?
All the, my lord, recruitment rules are guided by DOPT guidelines, my lord. DOPT says, my lord, at page 41, page 41, DOPT says, my lord, in terms of PPC recommendation, rules are required to be amended.
Hmm.
And accordingly, my lord,
Where is the DOPT
my lord, page 41, my lord.
date?
Date, my lord, 5th of May, 1998.
This OM is for
OM is for, my lord,
or implementing the fifth CPC
My lord,
recommendation.
right.
Yes, Mr. Chakraborty.
Lordship, following some of the recommendation of the sixth CPC, we have already implemented some of the
Fifth.
sixth also, Lordship, that I have stated in paragraph 3.
No, regarding this recommendation of incorporating provisions in the rules.
Lordship,
So
this
they-
merger was done in Lordship in the year 2006 with effect from 1/1/2006.
Merger.
Merger, Lordship. That we have implemented, Lordship. And the phase has also been, Lordship.
From merger from
The three, that is, Lordship, post of overseer,
no, from
Superintendent one,
no, from which date? Effective from
effect given from benefits given from 1/1/2006.
1/1/2006. Yes.
Here lies the problem, my lord. It was to
Okay.
be,
Will come. No, what are
And paragraph 6, Lordship, we have stated, Lordship, difference
your-
in space settle and Lordship, financial upgradation also been given, Lordship, wherever applicable, Lordship. That we have stated in paragraph 7.
page of your affidavit?
Affidavit, Lordship.
You filed affidavit.
Lordship.
Paragraph?
Lordship, come to paragraph 3, Lordship. We have stated that the six Central Pay Commission recommendation numbers so and so, we have followed that. And upgraded overseer with promotional post of superintendent, Lordship. And upon merger, the pay scale of Lordship will be pay band 2, we have given them in the grade pay of 4,200, Lordship. So some of the recommendation which are acceptable, we have implemented. Lordship. So far as promotion of the amendment that, Lordship, that is, Lordship, each of the department has their own service rule. We have service rule, Lordship, we have annexed to that, by which the junior engineer can be promoted to the post of assistant engineer.
Where page?
Page, I don't know about the running page. It is 39 of our affidavit.
Okay, we'll have it. Thirty-nine.
39. Assistant engineer civil.
Yes.
And then assistant engineer next
Where
page.
page? Next page.
Next page, assistant engineers, electrical and mechanical, also found on by promotion,
Yes. Junior engineer.
junior engineer.
Then
Then they can compete lots of whenever.
junior promotion, what post? By promotion. Assistant engineer, okay. From junior engineer.
From junior.
No.
Only one thing we have, the cadre review part that we have stated is under consideration. Lordship, to that regard, we document directors to expedite that. Then there will be chances of promotion, more promotion. Lordship.
Where is the statement
Lordship, paragraph 28.
that you are, that is
It's
still
under
under
consideration.
consideration?
It has been proposed to create 650 posts. At present, perhaps it is 230 posts. So they will have a much higher chance
Where
of promotion.
paragraph?
28. Under consideration.
Help for example. It is help for the this has been done by
Cadre review has been done.
subsequently done.
Then-
At the time of filing affidavit, as well as it was not there.
And if it is done, your, one of the grievance is gone.
Yes, yes.
The other grievance also, we see that the rules already have an avenue, a provision for promotion from JE to assistant engineer.
Yes.
After that, difficult. Okay.
Malad, what happened? Malad, as my friend has pointed out, paragraph 6.
Yes.
Paragraph 6. This pay scale has been implemented with effect from 1/1/2006.
Yes.
Subsequently, this honorable court, in another petition, has directed the authority to implement this pay scale, my lord, with effect from 1/1/96.
Hmm.
1/1/96, because this was the recommendation made by the fifth citizen.
Hmm.
And accordingly, my lord, this honorable court held that the petitioners were entitled to the pay scale of 5,000 to 8,000 with effect from 1996, 1/1/1996.
In which case?
Yes, I have got
In
that.
BRO case?
In BRO.
Yes,
the
what
case
do you
of-
say on that?
Chandra Kumar. It of- That was challenge before the division bench. Division bench has negated the appeal. It was went up to Supreme Court. SLP was also dismissed.
Lordship, in paragraph 4, we have stated, Lordship, For fixation of pay, we have taken the effect from 1/1/96. For actual benefits has been given from 1/1/2000.
Read paragraph 30 of this,
Paragraph 4 of
no,
our.
paragraph 30 of the judgment. You have a copy?
No.
Have you given a copy?
Areas are also there to be paid.
Here, ADS has been given. 30,000. That was. Decided in 2020.
Hmm.
There in 2024. The 3 years, perhaps that 3 years.
Now,
barrier of-
how the facts will be different? In fact, this case, which was decided on 18th of February 2020,
Good.
was filed in 2015. It's a
No.
later case.
Yes,
They had approached on an earlier date, 2014 matter. Let us see what is the relief you are seeking, Mr. Saikia?
This is followed only for amendment of the rule file. Page 30.
Bring equity in parity. That restore seniority. There is nothing on that in that line.
So far that that is not. in the-
So, my first line was very long drafted with petition. I could not improve this case.
You consider this aspect. We will not pass any directions. But since there is already a benefit given by the court to one of the similarly placed, they will approach you, we will consider.
One more aspect, my lord. In other departments, my lord, there is a provision for lateral departmental, my lord, test for promotion. 50% posts are reserved for promotion for seniority basis
Hmm,
and 50% on merit.
hmm.
But some meritorious candidate, my lord, they have to work along with the other persons, my lord, for promotion. They have no chance of, my lord, bypassing the other person.
That part will be difficult. Okay, please write. 14 numbers of petitions have joined together in this petition filed under Article 226 of the Constitution of India with the primary grievance of implementation of the fifth CPC recommendation, which was also of the year 1996, which was also endorsed by the Department of Personnel and Training, WIDE OM, dated 25/5/1998. Full stop. Para. The facts projected are that the petitioners, who are personnel of the Border Road Organization, within bracket BRO, no, who are not, are personnel of the Border Road Organization, full stop. No, person, are junior engineers in the Border Road Organization, personnel. Initially, comma, there were three sections, what do you call? Sections or groups or what? Three different posts, namely overseer, comma, superintendent grade 2 and superintendent grade 3, meant for diploma holders. Full stop. However, by the fifth CPC recommendation of the year 1996, comma, the aforesaid three posts were merged into one cadre of junior engineer. Full stop. The commission further recommended for cadre review so as to brighten the chance of promotion of junior engineers to the next higher post of assistant engineer. Full stop. It is the case of the petitioners that while for other similarly placed organizations, the rules were amended, no such amendments were brought in for the rules governing the BRO personnel. Full stop. Para. I have heard Sri I.H. Sekya, learned counsel for the petitioners, whereas the respondents are represented by Sri B. Chakraborty, the learned CGC. Full stop. Para. Sri Sekya, the learned counsel for the petitioners, has submitted that the omission on the part of the respondent authority in not making suitable amendments in the rules is apparently discriminatory and arbitrary, inasmuch as similarly situated persons in other organizations were granted such benefits by amendment of the concerned rules in terms of the recommendation of the 5th CPC. Full stop. Attention of this court has also been drawn to the office memorandum of the DOPT dated 25/5/1998, as per which, the recommendations were directed to be implemented. Full stop. It is submitted that due to non-implementation of the 5th CPC recommendation, the petitioners are stagnating and the same is against the interest of public service. Full stop. Para. Sri Saikya, the learned counsel, has also submitted, has also placed before this court an order dated 18/2/2020 of this court passed in WPC 1537/2015, in which relief to a similarly situated person was granted to the extent of arrears of pay. Full stop. The learned counsel has also informed that the aforesaid order was unsuccessfully appealed by the department in the before the division bench and the Honorable Supreme Court.
WA 104/2020.
In before the Honorable Division Bench in WA
104/2020.
104 of 2020 and also before the Honorable Supreme Court. Do you have SLP number?
SLP number 9702
In SLP number
2022.
9702 of 2022.
Two.
Full stop. Yes. Para. Per contrast, Sri Chakraborty, the learned CGC, by referring to the affidavit in opposition filed on 24/11/2015 has submitted that the projection made on behalf of the petitioners is not wholly correct. Full stop. It is submitted that the merger was given effect from 1/1/2006, whereafter all personnel were given proper pay band benefits, fitment, proper pay band fitment, upgradation in pay, and
Calculation has been done from 1/1/96, but actual benefit depend from 1/1/2000.
and other benefits, full stop. He clarifies that the fitment has been done from 1/1/1996 and the actual benefits have been given from 1/1/2006. Full stop. As regards the submission that there is no avenue for promotion, the learned CGC has drawn the attention of this court to the Border Roads Engineering Service Group B rules, 1977. And the notification issued and the notification dated 31/7/2012 issued thereunder. Whereby the Ministry of Road Transport and Highways, Border Roads Development Board, General Reserve Engineering Force, bracket BRO, bracket close, Assistant Engineer, within bracket Civil, bracket close, and Assistant Engineer, bracket Electrical and Mechanical, bracket close, Group B to inverted, post POSTS, recruitment rules, 2012 were notified. Full stop. It is submitted that under the said rules, there is a provision for promotion of junior engineers to the cadre of assistant engineer, and therefore the contention of the petitioners are not correct. Full stop. As regards the recommendation for increasing the cadre strength by making suitable cadre review, the learned CGC has referred to the averments made in paragraph 28 of the affidavit in opposition, wherein it has been stated that such exercise for cadre review is on. Full stop. Sarah? As regards the order dated 18/2/2020, passed in WPC 1537 of 2015 is concerned, the learned CGC has submitted that the contention of the petitioner in that case was wholly different, and therefore the same directions may not be applicable. And therefore, the petitioners in this case are not entitled to seek a similar direction. Full stop. Para. Sri Saikya, the learned counsel for the petitioner, has, however, fairly submitted that the cadre review exercise has, in the meantime, been finalized and the cadre strength has been increased. Full stop. However, the payment of arrears have not been done. Full stop. Para. To appreciate and examine the rival contentions, comma, it would be convenient if the relief prayed for in this writ petition is perused, which is extracted here in below, page 30. Full stop. The primary relief is to bring an equity and parity in the relevant recruitment rules in the aspect of promotion from junior engineers to assistant engineers and further promotion. Full stop. The petitioners have further prayed for giving their promotions retrospective effects and also restoration of seniority. Full stop. There is no specific prayer for any arrears, for any for release of payments of arrears of pay in terms of the recommendation of the 5th CPC. Full stop. Be that as it may, comma, the aspect of amendment of the rules governing the parties is an aspect which is wholly within the domain of the employer, and there cannot be any, and this court cannot issue a mandamus for amending such rules. Full stop. That apart, comma, this court has noticed that in fact the rules were amended by notification dated 31/7/2012, wherein from which it appears that for the post of assistant engineers, comma, there is a promotional avenue from junior engineers. Full stop. This court has also taken into consideration the submission made on behalf of the respondents that the merger was given effect from 1/1/2006, and in terms of the 5th CPC recommendation and the DOPT office memorandum dated 25/5/1998, comma, all junior engineers in the BRO were given proper pay band fitment, comma, upgradation, and actual benefits from 1/1/2006 and the notional benefits from 1/1/1996. Full stop. In this connection, comma, the averments, the relevant averments made in the affidavit in opposition is extracted here in below. Page 100. Paragraph 3. Full stop. As regards the grievance of the petitioner relating to cadre review, comma, as observed above, comma, such cadre review has already been done in the meantime, and therefore there cannot be any existing grievance on that aspect. Full stop. In view of the aforesaid discussion and the facts and circumstances, comma, this court is of the view that no relief can be granted to the petitioners in this case. Full stop. Para. This brings this court to the aspect of the directions contained in the order dated 18/2/2020 passed by this court in WPC 1537/2015. Full stop. This court has noticed that the subject of adjudication in that case was different from the issues raised and the relief prayed for in this case. Full stop. At the same time, comma, this court cannot totally overlook the aspect that the incumbent in that case was also a junior engineer of the same organization and was identically placed. Full stop. In view of that, comma, while dismissing this writ petition, comma, the petitioners are granted liberty to file individual representations for grant of the monetary benefits for the period in question, which was granted to the petitioner in WPC 1537/2015. Full stop. In the event such representations are submitted, comma, the same are to be considered and disposed of by a speaking order within a period of 3 months from the date of receipt of the same. এই যেটা 1537 লিখিছে তাতে এই হেৰিটো নাম লিখি দিবা পাৰ্টিৰ নাম অকল ভাৰ্চেছ সোয়েনসো Yes.
The lordship, my lord, I have challenged the dismissal from service, my lord. The petitioner is my lord, was a office assistant of the Assam Gramin Vikas Bank, and for departmental proceeding he was dismissed from service, my lord. And I have challenged that my lord, this is only on ground that only one ground that my lord, as per Rule 42 of Assam Gramin Vikas Bank Regulation 2010, my lord. There is a provision for common inquiry or joint inquiry. The charge against the petitioner as well as the officers, my lord, the same charge, my lord, but the departmental inquiry hold separately, my lord, and that those 3 officers, my lord, got my lord, minor penalties, but their petitioners got my lord, major penalty, my lord, as per my lord, regulation 39(2)(b), my lord,
What is the
dismissal.
major penalty? Dismissal.
Dismissal, my lord.
And the other officers?
Other malot stated malot in their affidavit stated that malot got malot minor penalty
Like,
malot.
like minor penalty, like what?
But
Now, there are various minor penalties. What penalty were they inflicted with?
it is not known to me, my lord.
Now, how are you making out a case of discrimination?
Malot,
Simply saying
because
minor
malot,
penalty will not do.
first initially malot the stock was notice was issued, my lord.
No, no. What is the minor penalty? If you do not know what is the minor penalty, how do you know it's minor penalty? It may be
Minor penalty as per regulation, my lord.
Now, how do you know it is a minor penalty and they are not dismissed? You don't know the punishment imposed.
Malot, in affidavit, opposition stated that malot that initiated the departmental proceeding against those officers, malot, and got malot the lesser penalty, malot. In the affidavit, malot, it
Now,
is
what is the
reflected.
lesser penalty? We are asking you, what is the lesser penalty? No idea.
Malot,
Yes, Mr. Dutta, can something be done?
My lord, so far this case is concerned, if your lordship look at the charge sheet, the misappropriation of the bank money, it has been fortified by the disciplinary proceedings record. My lord, if your lordship look at MW, the evidence of the MW1 and MW2 is emphatically clear.
No, no. We are not on the merits of the charges. Charges may, and bank employee, we know the rigors which you have to apply.
My lord,
Doctrine of absolute good faith, and
Yeah.
he holds money in public trust,
Right.
public money in trust. That having said that, if there are other persons against whom the
Yes.
same charges were there,
that my lord, the charges are not the same. There, my lord, those officers were negligent. But there is no malevolent intention to make a personal gain out of that man. That is
Whereas-
the difference.
whereas the petitioner has personal gain.
Exactly. And he has admitted he has returned the money. My lord, returning money, my lord, the misconduct remains.
no, my
It
lord.
it will not obliterate the misconduct. Even my lord, Apex Court has said along with the interest, if you pay, then
No, no,
also
no.
my lord,
The aspect of misappropriation will still be there.
that my lord.
Returning will not obliterate the
Exactly.
aspect of misconduct.
That's the difference between the other officers and this officer.
Malot, only malot signatory of the check, my lord, is the best officers, my lord. I am not the signatory, I am the cashier, my lord. I duty, my lord, entrusted to entry the my lord, credit and debit vouchers, my lord. And they,
Mr. Padgiri, we may not go to the merits of your
my lord,
how you have denied the
My lord.
allegation. We may definitely prima facie have a look, overall look, how it has proceeded, but we'll not go deep into
my lord,
the aspect of proof or how you have it was. We'll see how what procedures were adopted, whether you are given a fair chance.
my lord,
If you are making out a case of procedural illegality or irregularity, infirmity, then it's a different matter.
my lord,
And the second aspect is the proportionality of the penalty. Proportionally, perhaps you don't have a case. Bank employee, misappropriation, no case for proportionality. Only case is the first aspect, impropriety,
Well,
infirmity in the procedures adopted. That you hardly have, and discrimination, we have not gone deep into, we'll definitely hear.
my lord.
Mr. Doctor says that you are not similarly or identically.
But,
placed
my
with-
lord, I have annexed, my lord, in additional affidavit, my lord, the first focus notice. That three officers, my lord. It from that perusal of that, my lord, first focus notice, that charge is same with the my lord petitioner, my lord. Kindly see, my lord, page 120, my lord.
Okay, let us hear then. Yes, when did you enter in service? Just give us the facts.
My lord, text, my lord, the petitioner entered in service, my lord, in the year 1991, my lord.
In the which bank?
My lord, initially, my lord, Kasar Gramin Vikas Bank, my lord. As cashier, clerk cum cashier. Thereafter, that Kasar Gramin Vikas Bank merged with the, my lord, amalgamated with two other bank, my lord, and namely, my lord, Assam Gramin Vikas Bank thereafter. And
Yes.
While the petitioner served as office assistant in the regional office at Silchar, my lord, he was suspended by the order dated 25/7/2011. Annex 1, my lord,
25/7/2011,
11 suspended.
Which date? Which page?
Page, my lord, 25, my lord,
25. Okay. Petition suspended.
suspended.
Yes.
And thereafter, my lord, first show cause notice was issued, my lord, kindly see page 26.
Date?
Date, my lord, 24/8/2011.
24/8/11. After a month of your suspension, you are given the show cause notice.
My lord,
Page 26, you had said?
26, my lord.
Okay. Yes.
My lord, on that, my lord, show cause notice, three, my lord, causes, my lord,
Three allegations.
my lord,
Three
described,
allegations.
my lord. One, my lord, on 14/2/2009, you have debited call deposit by rupees 90,000 in computer without any call deposit receipt under your user ID NLU as operator for credit to bank account Axis Bank and obtained one at per stake number so in the same sum down on Axis Bank favoring your account with UCO Bank filter and thereby you have misappropriated bank money. And second, my lord, 21/7/2009,
Yes.
same thing, my lord, amount is different. And third, my lord, 19/11/2008, it is same thing, my lord, amount is different. Fact is that, my lord, the Grameen Vikas Bank maintained a stake, my lord, of Axis Bank and said Axis Bank stake issued in favor of the petitioner account, my lord.
Petitioner's account, your account.
Petitioner's, my lord, account.
The checks were issued in your account.
Petitioner account under a different UCO Bank account, my lord. And that three checks, my lord, signatory of that checks, my lord, are the officers, my lord. I am the clerk, my lord.
Now, this amount, let us read the first. Also, you have debited call deposit of 90,000
My lord.
in computer without any for credit and obtained one at per check. Yes. For the same.
At per stake number 29732.
No, that is not what you have projected. This amount was debited to have a check in your favor
No, my lord, after issuing
With-
the check, my lord,
with
I
UCO
have-
Bank.
I entered into computer in the credit and debit vouchers, my lord,
This amount ultimately had gone in your account.
account, my lord.
What did you do?
Subsequently, my lord, refund, my lord. Initial two, I had a refund, my lord, after knowing that. And
No, you have debited in your account.
I am not debited, my lord, check issued by the
Sorry, you have
officers, my
debited,
lord.
you have debited from the computer and credited in your UCO Bank account.
But check, my lord, only account number is, my lord, shown, my lord, not by name, my lord.
You don't know
Therefore, I
your-
have known the account.
You don't know your account number. It's in the UCO Bank Silchar. It is been deposited in UCO Bank Silchar.
At the time of, my lord, entry in the, my lord, computer, my lord, I have no knowledge about that, where, what is the account number.
Difficult to accept.
And
Very
but
difficult.
custodian of that check is the officers, my lord. I am not, my lord. And two officers signed the check, my lord. Thereafter, my lord, credit vouchers, my lord, my lord, dealing with that, my lord, with
What is the
computer.
penalty imposed on them, Mr. Dotto?
Actually, that also I don't know. But I can take instruction from them.
But did you penalize them?
Yes, yes,
No, see.
because of the
No, no, no.
negligent act.
What we are just, it may be so that they were all in hand in gloves. His account was used,
My lord,
amount to his account and some that
It
subsequent
appears to be so.
subsequent
my lord,
division.
Account number was added subsequently by this delinquent. Because those officers, they were not knowing Just it was written UCO Bank Silchar. Now the account number was not put on that period.
No, but
Now
without,
they are obviously negligent, these people.
no, without there being any call deposit receipt,
Yes,
how was this call deposit made in the computer?
that's the thing, my lord. He has, your lordship kindly see, on 14/2/2009, you had debited call deposit of rupees 90,000. Now, if there is debit in the account, there must be corresponding credit. Now, the corresponding credit is not there. What he did, my lord, he has written UCO Bank Silchar. Now, UCO Bank Silchar, ultimately he has put his account number there. And from the disciplinary
And
proceeding,
this credit will come from where? This 90,000, before you extract it 90,000 and put it to UCO Bank, this 90,000 has to be deposited in your bank.
yes,
It has come from where? Where was to it was to come from where?
it comes, the check is sent for collection. And for collecting the, my lord, if you deposit certain amount, I mean,
A check.
debit,
Check.
if it is debited in certain account, then my lord, it must be credited in other account in order to balance that. Now, your lordship will say that credit amount should have been in the account of the Assam Gramin Vikas Bank, but it was never credited in AGVB's account. It was credited in his account. And when he realized that he did all this mischief, my lord, he refunded it on, my lord, past 14/2/2009, that mischief was done. He is refunded it on 29/11/2010. And second deposit was on 1/12/2010. So these are the accounting jugglery, my lord, in banking transaction.
Okay.
And
Yes.
Malot, the stake custodian Malot of the stake Malot is the officers Malot. They put their signatures Malot. And no doubt they were involved in that debt with the Malot assuming Malot. But the bank Malot initiated the departmental proceeding against the petitioner separately and officers separately Malot. And Rule 42 of the Assam Bank Regulation Malot. Kindly see, my lord, I have annexed, my lord, the regulation, my lord.
Page.
Page, my lord, kindly 136.
Yes.
42. Common inquiry. 136 page. May I read, my lord? Notwithstanding anything contained in this regulation, if two officers in different grade or an officer and an employee are involved jointly in an incident and disciplinary proceeding are sought to be instituted against both of them, the chairman is of the opinion that having regard to the facts and circumstances of the case, the competent authority in respect of both the officers and employee to be the same, the chairman may direct the competent authority in respect the officers shall be the competent authority in respect of both of the officers and employee involved, and a common inquiry shall be held into the charges against both of them. That rules violated by the
Is it a mandatory requirement?
Malot
Is it a, is it
shall
a,
be held
Chairman
into
may,
the charges.
wording is clear, chairman may.
no, is it a mandatory or is it a facility or a liberty granted to the organization to have a common inquiry?
Malot. Should be the same, the chairman may direct the competent authority in respect of officers shall be the competent authority in respect of the board of the officers. therefore, my lord,
No,
common
no,
inquiry,
so to test your submission,
my lord.
the question of prejudice will come. You have to plead prejudice because not holding of a common inquiry, I had suffered prejudice.
My lord.
But if you are not able to show any prejudice which has been caused to you, then we don't think that this will come into your aid.
On
What
this,
prejudice did you suffer? Were
On-
you not given adequate opportunity to defend yourself?
my lord, educate opportunity, my lord, on this regard, my lord, I have, my lord, first, my lord, the main defect is, my lord, the department, in the departmental proceeding, my lord, the witness, my lord. Initially, my lord, the list of witness, two witness, my lord, and thereafter, my lord, another witness added, my lord, which is the may also involved in this incident, my lord. Gita Sri Bhattakur, my lord. He also the signatories of the stake, my lord.
It can be witness, even an
And-
accused can be an approver. What is the difficulty?
And second thing, my lord, in departmental proceeding,
Where you were denied an opportunity of cross-examination.
my lord, that is I filed representation to engage the, my lord, legal practitioner, my lord.
Legal practitioner, it may not be
But it
may
is
not be a
refused,
matter
my
of
lord.
right. You may be entitled for defense assistant, but
My
not a
lord.
legal practitioner. Was the bank having a legal practitioner?
No, no, my lord.
Then
That's why, my lord, rejected the, my lord, claim, my lord. And after second stock was noticed, my lord, it was also stated, my lord, that, my lord, opportunity has not been given to
For?
cross the, my lord, witness, my lord,
cross-examine.
cross-examine them.
Did you cross-examine or not?
Not, my lord.
Were you given an opportunity or not?
My lord, it is stated in second stock was notice, stated that, my lord, no opportunity has given, my lord.
No, were you given? We are asking. We are not the disciplinary authority.
My lord.
We are asking you whether you are given an opportunity to cross-examine or not.
No, my lord.
Where have you stated?
Paragraph. My lord, paragraph 8, my lord. Although prayer was made to the inquiry officer
Hmm.
to defer the examination of witness till appointment of the
No,
defense,
that is not the thing.
paragraph 8, last portion.
Yes. In defending himself and towards effective cross-examination and taken, you are not denied. There is no student. Come to paragraph 10.
10, my lord.
10
Then the
towards
petitioner
the last part.
Last part, my lord. Page 15,
Paragraph 10, page 14.
14,
Even the questions which were allowed in cross-examination
my lord.
had
Almost
utmost
relevance towards bringing out the innocence of the petitioner who were not answered by the state witness, and the inquiry and the presenting officer did not persuade the state witness to answer.
you admit that you were given a cross-examination. Not answering is a different aspect.
My lord. To mention, my lord, common inquiry regarding common inquiry.
That we may not agree.
regarding common inquiry, my lord, the and parity of the punishment, this division bench, my lord, 2009 to JLT, my lord, Omresh
Yes.
Narayan Singh, my lord, category will stated, my lord. Distinction 3, my lord,
Which one?
3, my lord, take my 3.
Yes, what has been stated here?
In that case, my lord, the branch manager and my lord, two different person, my lord, tested punishment, my lord.
What has been stated here?
My lord. Paragraph 18, that the second
Yes, please read.
content visualized by the Honorable Appeals Court as stated above exists the present case is not in doubt. The charges against the appellant and Sri Kolyan Chakraborty that were found to be established were largely similar. Insofar as the first condition concerned the situation were out for the 4 different kinds of major punishment contemplated by the provisions of the regulation. The major punishment of reduction of basic pay was imposed on Sri Kolyan Chakraborty with due regard to the charges level, as evident from the order of penalty of Sri Kolyan Chakraborty dated 27/4/99, it can hardly be said that the state punishment is illegal and invalid on the face of it, which is the test that has to be applied for the purpose of the limited scrutiny that would be permissible in situations like the present. After all time, and again, it has been acknowledged that the employer is the best judge of the quantum of the punishment, and thereafter, operative portion test paragraph 21. In the light of what has been discussed above, we are the view that the punishment imposed on the appellant, removal from service, should be interfered by us. The state punishment, therefore, is set aside and matter is remitted to the respondent to take decision on the matter in the light of the principle of law and our observation contained in the present order. Following such de novo decision in the matter, all consequent benefits as may be reserved to the appellant, including protection of pension, pension.
Now, how is this benefiting you, this judgment? Hmm?
My lord,
How does it benefit you? Here, the challenge
my lord,
on the aspect of the punishment of removal, I think, or dismissal
my lord,
was structured that for charges which are graver in respect of some other officer,
my
a
lord,
lesser penalty was given.
my lord,
That is a different case altogether. Here, it is not a case of discriminatory punishment. You are trying to project that in the same transaction, 3 other officers were also
involved,
charged,
my lord,
and a common inquiry was not held. Separate inquiries were held, and they were given
lesser
lesser
punishment,
penalty.
my lord,
Now, this to examine your contention, we have to see whether prima facie the allegations against the other officers is exactly the same. Number 2, what is more important, what are the materials to hold them, that how much was their culpability in the offense.
my lord,
if it is held that they are negligent, for which some penalty has indeed been granted, and you are actually the main person who had benefited and returned the amount, then a case of different treatment may arise. It may not be a discrimination per se.
My humble submission, my lord, main my lord, allegation is main involved in two officers because he's the signatory of the my lord, account check, my lord. And that has not been my lord, even my lord, called to the witness
What
box
is your
also, my
age?
lord.
What is your age?
Yes, my lord, 54 years
Now,
now, my
presently.
lord.
Difficult. But do you have any rulings that the Rule 42 is mandatory in nature? Because reading of 42 gives the idea that a discretion, a liberty is granted to the authority to have a common inquiry also.
My lord.
Will it mean that in common inquiry is a must? If you hold a separate inquiry, the proceedings will be vitiated? Is there anything? No.
No, my lord.
Well, let us hear Mr. Datta. What are the other cases you are trying to rely on?
My lord, clarity of my lord.
Parity would come when the allegations and the materials against each of the officers are exactly the same.
My lord.
Mr. Datta.
I'll take your lordship to the charges that page 30 minutes.
30.
Visit. Article of charge number 1. On 14/2/2009, you had debited call deposit by rupees 90,000 in computer without any call deposit receipt.
Mr. Padgiri, have your seat?
Now, my lord, in their read petition, they have said
Yes.
they always make entry in the computer when they get a receipt. Now, here, my lord, the charge is that without any call deposit receipt under your user ID NLU, as operator for credit to bank account Axis Bank and obtained one at par check date number so and so for the same sum drawn on Axis Bank favoring your account with UCO Bank, and thereby you have misappropriated bank's money. Now, second charge is also similar one, just after 5 months, that is on 21 July 2009. And the third charge, on 19/11/2008, you had debited deposit suspense account for rupees 5,87,675 in computer under your user ID so and so as operator to credit of banker's check account in favor of UCO Bank against which no voucher was prepared. Again, on 20/11/2008, you had debited banker's check account rupees 5 lakh so and so. But on 26/11/2008, you had debited deposit suspense account for rupees so and so in computer under your user ID as operator to credit of bank account Axis Bank, obtaining at par check favoring your account with UCO Bank, and thereby you had misappropriated bank money. Due to your aforesaid bank has sustained a loss of rupees 5,87,674. You had refunded the misappropriate amount as referred in 1 and 2. Have a pro check for rupees 90,000 on 29/11/2010 and cash recovery of rupees 96 6,362 on 1/12/2010. Now, these, my lord, 90,000 and 96,000, he has refunded back after a prolonged period. And that, my lord, it can be construed to be a misappropriation of the account for a temporary period. Now, it is alleged that during your tenure as clerk cum cashier at Silchar branch for the period from 21/5/2005 to 24/5/2010, you have misused the trust reposed on you by the bank and had committed serious manipulations in accounts and refund of rupees so and so from the bank in a fraudulent manner. The details of theft committed by you are given under. Now, the last para, page 31, last para, I will also kindly see. Due to your aforesaid.
Page?
Page 31, next page.
Yes,
Due to the last para, I'm
yes,
reading.
please.
Due to your aforesaid.
Yes, we have read this.
Yes, bank has.
That is the
sustained-
same reproduction of the
Well, Exactly.
page at page 30.
Yes, yes. And
Second- second-
thereby, my lord, he has violated the regulation 18 and 20. 18 and 20 speaks of, my lord, honesty, integrity and all. Now, your lordship may see the inquiry report. In
Page,
page 57, the last para, chart number 1,
57.
57. 57, in the bottom, your lordship will find chart number 1,
Charge number 1.
my lord.
It starts where? When does it start?
The charge number 1 on.
No, no,
42,
inquiry report starts which page?
inquiry report starts at page 55.
55.
Well.
What is the date?
The,
Okay, the date of the forwarding is there, 54.
yes, yes,
Second show cause notice,
my lord.
12/9.
12/9/2013. Now the chart 1 as you have seen, the PO's argument, the brief, then defense argument, then analysis of by the inquiry officer.
Yes.
After hearing both sides and examining
Page?
page 58, somewhat in the middle portion,
Yes.
analysis of chart by
Yes,
inquiry
yes.
officer. After hearing both sides and examining all relevant MEs, it is found that an amount of rupees 90,000 entered in computer through user ID of Nilendu Datta and amount was fraudulently credited in SBI account number so and so of Nilendu Datta with UCO Bank Silchar branch. The same was withdrawn from the account by Mr. Nilendu Datta. Here MW3, who had worked with Sri Nilendu Datta at Silchar branch from May 2005 to June 2010, confirmed that check number so and so of rupees 90,000 of Axis Bank Silchar, favoring UCO Bank Silchar, was written by Nilendu Datta, but no account number was given at the time of issuing of check, and it was subsequently written on the check, inserting account number so and so of Nilendu Datta. It is also confirmed by MW3 that all the check issuing schedule of that day was also written by Mr. Nilendu Datta, where UCO Bank was shown as payee without mentioning any specific account number, and which he did by putting his account number in the check letter on or crediting the amount in his personal account. It is also confirmed by UCO Bank Silchar branch through a letter dated so and so addressed to the manager regarding account holder details of the account number so and so is given below. Now, in all the charges, my lord, the operation was done in that manner on. And ultimately, my lord, you also will find the inquiry officer is given his finding at page 61. Thus, these charges also prove. Now, the last pair I am reading, my lord. Now, after the inquiry is over, I, as inquiry officer, have taken an appraisal of the evidence on record. The assessment of evidence in respect of each charge, finding on each charge, and the defense of the charge sheeted employee, and all other relevant matters relating to both sides of the inquiry. Indeed, I have critically examined the evidence and applied.
I'm just interrupting you.
Well.
Mr. Doctor, at page 58,
Yes,
date of, I've just seen this, date of opening, this account of this petitioner
yes,
in UCO Bank See the date of opening,
Your lordship is at page
same
58.
58, towards the, before the second last paragraph.
Yes,
Date of opening have you got?
11/12/2008.
11/12/2008.
yes.
This is the bank which he, account holder. Oh, through letter. It is confirmed by UCO Bank, the through letter, regarding the account of the petitioner in UCO Bank.
Eco
Correct?
Bank. Yes,
He has opened this on 11/12/2008.
yes,
So far as the first two amounts are concerned, no problem.
yes.
One is 14/2/2009. The three amounts are concerned, 90,000, 96,000 and 5 lakh something.
No, regarding 5 lakhs, my lord, that was not credited in his account.
That was what?
These two 90,000 and 96,000,
Oh,
that was credited in his account.
and with this 5 lakhs?
5 lakhs, my lord, that there is some, so far, my lord, the accounting jugglery that is there, but it was not credited in his
So
account.
what is the connection with this 5,87,000?
Yes, my lord, I
What is
will
the allegation?
go to that once again.
Yes.
Charge 3, on 19/11/2008, you had debited deposit suspense account for rupees 5,37,675
Hmm.
in computer under your user ID is operated to credit of banker's check account as per banker's check issue registered in favor of UCO Bank,
Yes.
against which no voucher was prepared.
Hmm.
Again, on 2011/2008, you had debited banker's check account of rupees so and so in computer under your user ID as operator for credit to deposit suspense account. But on 26/11/2008, you had debited deposit suspense account so and so in computer under your user ID as the operator to credit of bank account Axis Bank, obtaining a par check favoring your account with UCO Bank, and thereby you had, here is also melody, it seems it was credited in his account.
Well, how come? If the account was opened at a subsequent date,
My lord, let us see how the inquiry was dealt in regard to
charge number
charge
3.
3. Ma'am.
Yes.
The lordship will find that at page 59, the last,
Charge number 3.
yes, charge number 3. On 19/11/2008, you had debited deposit suspense account of rupees 5,87,675 to credit of banker's check account as per banker's check issue register in favor of UCO Bank, against which no voucher was prepared. Again, on 2011/2008, you have debited banker's check account for rupees so and so in computer under your user ID as operator for credit to deposit suspense account. But on 26/11/2008, you had debited deposit suspense account of rupees so and so in computer under your user ID as operator to the credit of bank account Axis Bank, obtaining at par check number so and so, favoring your account number with UCO Bank, and thereby you had misappropriated bank money. Now, the finding of the inquiry officer is the down below, my lord. Analysis of the charge number 3 by inquiry officer. After hearing both sides and examining and going through all relevant means, it is found that on 19/11/2008, chartered employee had debited deposit suspense account of rupees 5 lakhs and odd in computer and his ID as operator and credited banker's check account as per banker's check issue registered in favor of UCO Bank. Again, on 2011/2008, chartered employee had debited banker's check account of rupees so and so in computer under his user ID as operator and credited deposit suspense account. But on 26/11/2008, chartered employee had debited deposit suspense account for rupees so and so in computer under his user ID as operator and credited bank account by obtaining a check at par favoring UCO Bank Shilchar, and subsequently CSC put his account number in the check on the space after UCO Bank and get it deposited in his account with UCO Bank Filter. Here, one most important point has been observed, noted and found at the inquiry that CAC had obtained check number so and so dated 26/11/2008 for rupees 5,87,674. And thereafter, CAC had opened a SB account with UCO Bank Filter on 11/12/2008, that is 15 days after obtaining that check, to encash the fraudulently obtained check in his newly opened account with malafide intention to misappropriate the said amount to a personal account with UCO Bank. Due to above irregularities committed fraudulently by so-and-so, bank had sustained a loss of rupees so-and-so. Now the account was opened afterwards. That is on 11/12/2008. Corroboration of MW 3, 2, and 1 with chart number so-and-so, read with so-and-so, had fraudulently misappropriated bank's money and you approved the charge. by
These are
Executive.
serious charges, Mr. Padgiri.
My lord.
You don't have an account, you obtain a check in your name, open an account after 20 days. And in fact, this third charge should have been the first charge.
Yes,
First, not the first charge, first amount mentioned in the chronology.
right.
It started from 19/11/2008, then in February 9, then in July 9.
My lord, I have annexed the photocopy of that check, my lord. Kindly see page 170.
117.
7.
Yes. Yes.
Check was issued on 26/11/2008.
Hmm.
And that check signatory, my lord, two officers, my lord. And Anjan Bhattakur and Gita Sri, my lord. And they take stated UCO Bank Silchar account number so and so, so and so,
This account number is yours.
my lord.
When did you deposit? When was it?
My lord, I
When
am
was it
not
given for
deposit,
clearing? Clearing it was given on
I
12.
am not deposited, my lord. The
No,
bank, my lord,
see the clearing, 12/12.
12/12,
12/12, when the check is dated 26/11.
my lord. But opened on
12/12, why 12/12? Because he had opened the account on
Opened 11/12.
11/12.
11/12. But the signatory,
It's
my lord,
better not to dig any further.
Okay.
Something else may also come out now.
my lord, the office, that officer is also responsible, my lord. Yes, because my lord, he is the signatory, my lord. Without my lord, blank check, my lord.
You are the hero. They are your friends.
My lord, I am not a custodian of that check, my lord.
In a movie, they are the hero, and he has
My
got
lord,
some friends.
As per my duty, my lord, I am to just to entry the credit and the debit vouchers, my lord.
What is your name?
My lord,
Endatta.
Nilandu Datta. Check, my lord, only stated UCO Bank, Silchar, account number, spent.
Datta sir usually not like this. It's the exception. I think.
We do not know. We haven't. Have we said anything? We have not said anything.
That two officers also responsible, my lord, that issuing that check, my lord.
Your lordship, look at the check, how the account number was put later on. It can be
It is-
very well identified.
It is never proved, my lord.
Just for my clarification, this check is of the Axis Bank.
Axis,
It pertains to a particular account.
Hello.
This account 2710, that account number.
in the name of Grameen Vikas.
Okay. That is the bank's account.
Yes, my lord, the collection is done through that. And if you lordship look at the check once again, lordship will find UCO Bank filter, then my lord, in banking transaction, generally we also, when we issue a check,
No, what we're just trying to understand.
Right.
Axis Bank, an account is maintained with Axis Bank.
with the.
Grameen Vikas Bank maintain.
Maintained, this is the account number of Grameen Vikas,
Yes,
2710.
Right.
Okay. You are a bank, you yourself have an account in another bank, no
Yes.
problem. And now this check has been issued by Axis Bank.
yes.
Oh, no, the account holder.
No,
Account holder.
Account holder means, that means the
Grameen Vikas
Grameen
Bank.
Vikas Bank,
Silchar branch.
in favor of the UCO Bank, a
UCO
particular
Bank.
account in the UCO Bank.
UCO Bank filter, yes. Now, this check was sent for collection to the UCO Bank,
Not to the UCO, to the Axis Bank,
to the Axis Bank,
for deposit in the UCO Bank.
for deposit to the UCO Bank, and your lordship will see, after UCO Bank filter, we generally, when we issue a check in favor of so and so, say Mr. X,
Hmm.
after writing his name, we just give a marking there so that nobody can write there anything.
Hmm.
Likewise, my lord, the 5 lakh, there also give a mark. Now, your lordship can see UCO Bank filter account, then there is a marking your lordship has seen.
Hmm.
Now, subsequently, he has put this account. This account belongs to the bank.
But
But-
this stamp should have been of Axis Bank for collection. Where is the Axis Bank stamp?
Collecting bank has given.
UCO Bank.
this.
No,
In
UCO
UCO
Bank
Bank.
will only deposit the amount in the UCO Bank. It will go for collection to Axis Bank. See, I have a bank account in SBI.
Yes.
I give you a check. The moment I give you a check, the check will not go to your account. It will come for collection from my bank.
Yes.
And there has to be an endorsement, then it will go to your account. So this clearing is, why is the clearing by UCO Bank? Clearing should have been by Axis Bank. Just trying to understand this clearing stamp.
As per my understanding, my lord, the Assam Grameen Vikas Bank maintained a account in Axis Bank. Accordingly, my lord, Axis Bank provided check to the Assam Grameen Vikas. Bank.
Understood,
And
understood.
Assam Grameen Vikas Bank issued the check
In
to the UCO Bank.
yes, understood. Then this clearing, this stamp,
It is clearing by
Why-
the UCO Bank.
why UCO Bank? It should be from Axis Bank. Axis Bank, it has to be collected from Axis Bank account, paid to UCO Bank. Where is the endorsement by that it was sent to Axis for collection? Unless the bank where the account holder has the account from which the check has been issued, that clears.
My lord.
It will not be deposited in any, it can be deposited to, it can be given in name of UCO Bank, it can be given in the name of some individual. We are not in whose name the check has been issued. We are on who has issued the check and his account was where. Bank has been issued by the Assam Grameen Bank, and they had an account with the Axis Bank.
Axis Bank.
So the amount will be debited from Axis Bank and would be credited to the beneficiary's name,
My lord.
which is an account holder in the UCO Bank.
UCO Bank.
So UCO Bank is only the crediting part.
My lord.
The debiting part, Axis Bank clearance is, where is the clearance signature? The stamp endorsement.
The UCO Bank, my lord.
I have obtained from the my lord, list of documents, my lord, that check in the DP. my lord.
No, we're just trying to understand. There is no dispute with this.
My lord, this Axis Bank Limited, this check is with the Grameen Vikas Bank.
Now, you are
No.
the account holder.
Yes.
Let us make it very simple. You are an account holder with the Axis Bank.
Yes.
So Axis Bank gives you certain checks. You
Right.
can use those.
Yes.
So here, this is a bank, this is a check of the Axis Bank. Okay, and if you see, it's given to for Assam Gramin Vikas Bank main branch Silchar. This is the account holder.
Yes.
Before, where you put your signature.
Yes.
And you sign, you give it in favor of somebody. In this case, it was an account of the UCO Bank. You give it to an account holder in the UCO Bank Silchar.
This
No.
check will go to UCO Bank for their clearance.
UCO Bank will only credit your account, credit the amount to the account.
It is gone on clearance. Then after clearing, the UCO Bank will certify. If there is no money, then it may be returned also.
No money from where? Not in UCO Bank. No money in Axis Bank.
But then it is.
UCO is only the beneficiary. UCO it will be deposited. UCO has nothing to do from where the money has come. It is the Axis Bank from which the money will go. Check is of Axis
Your
Bank,
Lordship, you want to say that the Axis Bank will clear it.
obviously.
But then if your endorsement is UCO Bank,
UCO Bank. No, UCO Bank, there can be an endorsement that has been deposited. But clearing has to be done by Axis Bank. It doesn't matter. These are all electronically and this is not in dispute.
yes, it is not in dispute.
Now we are just trying to understand the bank parlance and the procedure, which stamp is generally
Right.
used.
These are sometimes very confusing.
Because see, the beneficiary bank is not too much to look into.
Right,
They have an amount to be deposited, we deposit.
exactly.
It is the bank from which the amount will go. They have to verify, yes,
They-
who's
they
the
will have to
account?
verify.
Yes. Is it been signed? Who is the account holder? Who has signed? Yes, everything okay, clear.
If there
Go.
is a money, it will be
Yeah,
clear.
yeah, money. Because you see in check bouncing cases, this is done by the bank where the account is there, from
Yes,
which the debit is been made, if there is no money.
Nowadays, my lord, we have forgotten this part because the endorsement is different.
Mr. Padgiri, see, for a bank employee,
My lord.
there can be different misconducts. Maybe one, this you have exceeded your discretion, given a loan without proper verification, or you have done something which is not essentially strictly permitted by law. Those are one part of allegations, or taken a loan not permitted, or giving a loan in the spouse names or some relative. But those are not within the realm of misappropriation. Here is a case of misappropriation. It's entirely different. Here you're dealing with public money. The other cases, it's your discretion. It's the power of excess. That also it's a misconduct. But this is a very serious kind of a misconduct.
But it is jointly liable, the officers also, my lord. He is the signatories, my lord.
Signatories, no. Signatories for negligence, they have been held
Is
liable.
it that part, negligence part of that officers also, my lord? It's because, my lord,
Will you
They
get
put that-
anything? Suppose will you get anything? We hold that yes, they are equally liable. Give him the dismissal. What relief will you get?
What?
And it is not once. The first instance of a check dated 1926-11-2008, you hold back till you open the account on 11-12-2008,
Yes.
then you deposit on 12-8, 12-12.
my lord.
You may not be. Any case law, Mr. Dutta, you're referring on misappropriation?
Yes. I will not bother you, Lordship, to give many of the decisions. Few of the judgment I am just sending.
Just one or two.
Right.
The main.
You know, the 2023 SCC,
2020,
3 SCC 423. 423.
Name?
My lord, State of Karnataka and another versus N. Gangaraj. Paragraph 8 to 15. I'm not just reading out.
N. Gangaraj.
N. Rangaraj.
Rangaraj.
Gangaraj.
Gangaraj.
My lord.
Yes. Paragraph?
Paragraph 8 to 15.
Yes. What is the principle?
My lord, I'll just read out. We find that the entire. My lord, I have a copy. I'll just give it to you. Lord, these are all your lordship is aware of. There are 8, my lord. We find that the interference in the order of punishment by the tribunal as affirmed by the High Court suffers from patent error. The power of judicial review is confined to the decision-making process. The power of judicial review conferred on the Constitutional Court or on the tribunal is not that of an appellate authority. In state of AP versus so-and-so, previous bench of this court has held that the High Court.
We are not, these are all settled on the part
Yes,
of
yes.
that misappropriation is a penalty where dismissal can be held to be
Right,
a
right.
proper penalty.
And exactly on that point, I'll give you a topic. Melody, your lordship may take this 2006 6 STC, page
Okay.
187,
2006,
volume 6 STC, page 187.
name?
Divisional Controller, any KRPC. Yes, no?
Hutilal.
H. Hamare. Lord, there was a misappropriation of rupees 360. The appeals court is state. Lord, I am handing over to you, lordship.
Divisional controller versus, okay.
Controller, any KRTC.
Paragraph?
Paragraph 18, 19, 20, 21, 22. In para 18, my lord, in the instant case, the misappropriation of the funds by the delinquent employee was only rupees 360.95. This court has considered the punishment that may be awarded to the delinquent employee who misappropriates the funds of the corporation. And the factors to be considered. This court in a category of judgment held that the loss of confidence is the primary factor and not the amount of money misappropriated, and that the sympathy or generosity cannot be a factor which is impermissible in law. Then para 19. In this context, it is useful to refer to the findings of the domestic tribunal which have already been extracted above in paragraph so and so. Before the inquiry of Mr. So and so were marked, which have not been refuted, nor was the veracity of witness tested. The inquiry officer has stated that he has carefully examined the evidence of so and so, and the documents marked which fully reveal that the delinquent has committed not only misconduct but misappropriated the cash. MWR, if one was not cross-examined by the delinquent employee. In reply, the delinquent has simply denied the charges, stating that to be based. Then your lordship may see. Para 20. Once the domestic tribunal, based on evidence, comes to a particular conclusion Normally, it is not open to the tribunal and the court to substitute their subjective opinion. And coming to the question of quantum of punishment, this court in divisional controller versus so and so held. Coming to the question of quantum of punishment, one should bear in mind the fact that it is not the amount of money misappropriated that becomes primary factor for awarding punishment. On the contrary, it is the loss of confidence which is the primary factor to be taken into consideration. In our opinion, when a person is found guilty of misappropriating the corporation funds, there is nothing wrong in the corporation losing confidence or faith in such a person and awarding a punishment of this is all about. And then, my lord, another judgment that even if the money is returned, then also, my lord, that is 2007-15 SCC, page 775, paragraph 6.
Name?
Name is Narendranath Bhalla versus state of Uttar Pradesh.
Paragraph?
Paragraph 6. Lord, I'll just read out. Learned counsel for the paragraph 6.
Yes, please.
Learned counsel for the appellant also submitted that the appellant has already paid back the money which was held proved against him and he had misappropriated. Mere repayment of money does not absolve him of serious charge of misappropriation. The last submission that the punishment imposed on the appellant is too harsh also does not appeal to us, having regard to the serious nature of charges, including the misappropriation of money and issuing a receipt on plain paper and reflecting it in the official record as something else. The decision of so and so relied on by the learned counsel for the appellant does not help him, as that is the case which governs the facts
Okay.
of that case.
Okay.
Lord, another judgment your lordship may take. 2008 SCC,
2000?
8 SCC, page 92, paragraph 42, 41.
2008,
2008 volume 8 SCC,
32.
page 92, paragraph 41.
Name?
State Bank of India and others versus S.N. Goel. Lord, a small paragraph I'll read it. Lordship may see the last page, page 115.
115.
115, paragraph 49.
41 you had said?
Sorry, 41. At the relevant point of time, the respondent was functioning as a branch manager. The bank survives on the trust of its clientele and constitutes. The position of the manager of the bank is a matter of great trust. The employees of the bank, in particular the manager, are expected to act with absolute integrity and honesty in handling the funds of the customers, borrowers of the bank. Any misappropriation, even temporary, my lord, even my lord, in this case, it can be construed that is temporary. Then also, my lord, it's a great charge. Any misappropriation, even temporary, or the funds of the bank or its customers, borrowers, constitutes a serious misconduct, inviting several punishments. When a borrower makes any payment towards the loan, the manager of the bank receives such amount required to credit it immediately to the borrower's account. The matter is of be viewed lightly or leniently. It will encourage other bank employees to indulge in such activities. Now, another case, my lord, appears court is saying the position of the bank employees, the manager, accountant, their position must be like Caesar's wife. That means, my lord, as your lordship knows that Julius Caesar, he has divorced his wife because the Caesar's wife, possibly third wife, Pompey, my lord, she hosted a party. There, my lord, some unknown person sneaked into the meeting. Then Julius Caesar thought it must be some unwanted person. He was caught, then he was sent to trial. Now, after the conviction, my lord, he divorced his wife because he thought some integrity is in question so far his wife is concerned. So, my lord, he wanted who is Julius Caesar's wife must be beyond any suspicion. The Supreme Court, in many of the decisions, your lordship has found that, my lord, their position should be like Caesar's wife beyond any doubt. That's why, my lord, regulation 18 and 20, it is added that their position must be very honest. They must be beyond any integrity. All these things must be maintained because these are should be inbuilt requirement in their conduct and character.
Okay.
That's it.
The initiation of a disciplinary proceeding which had culminated in an order of penalty of dismissal from service dated 30/12/2013 is the subject matter of challenge in this writ petition. Full stop. The attempt of the petitioner to have his grievances redressed by approaching the appellate authority in the bank had also not yielded any favorable result, as his appeal was rejected on 3/4/2014. Full stop. Thereafter, the present petition has been filed. Full stop. Para. The facts, bereft of the details are narrated are that the petitioner was appointed in the year 1991 as a clerk cum cashier in the erstwhile Kachar Gramin Vikas Bank, which had subsequently merged and became the Assam Gramin Vikas Bank, within bracket hereinafter the bank. Full stop. In discharge of his duties, and the act of misconduct was detected, and accordingly on 25/7/2011, the petitioner was placed under suspension pending trial of a departmental proceeding. Full stop. The same was followed by a show cause notice dated 24/8/2011, which had 3 charges. Full stop. All the 3 charges relate to misappropriation of bank money of various amounts. Full stop. The show cause notice was replied to by the petitioner, and thereafter a memorandum of charge was issued on 11/4/2012, which was also denied which was also replied by the petitioner denying the charges. Full stop. On such denial, comma, an inquiry was initiated. Full stop. In the said inquiry, comma, 3 numbers of witnesses were produced by the bank, and after submission of the inquiry report, comma, the petitioner was issued a second show cause notice on 12/9/2013, which he had replied. Full stop. The respondent bank had thereafter issued another notice on 20/11/2013 on the proposed penalty, which was also replied to by the petitioner, whereafter void the impugned order dated 30/12/2013, comma, the petitioner was inflicted with the penalty of dismissal from service. Full stop. Para. As indicated above, comma, the departmental appeal was also rejected by the appellate authority void order dated 3/4/2014. Full stop. Para. I have heard Sri Padgiri, K.R. Padgiri, learned counsel for the petitioner, whereas the respondent bank is represented by Sri S. Datta, learned senior counsel, assisted by Ms. D. Musahari, S. Musahari. Full stop. Para. Sri Padgiri, the learned counsel, has contended that the inquiry suffers from procedural irregularities as no effective opportunity to cross-examine the witnesses were given to him. Full stop. The request of the petitioner to have assistance from a legal practitioner was also rejected. Full stop. Apart from the aforesaid grounds, comma, the learned counsel has submitted that along with the petitioner, comma, 3 other officers of the bank were also charged on the same allegations, and in this regard, comma, no common inquiry was held. Full stop. By drawing the attention of this court to the provisions of the Assam Gramin Vikas Bank Officers and Employees Service Regulations, 2010, more specifically, Regulation 42 thereof, the learned counsel has submitted that a common inquiry is prescribed when two officers in different grades, when several officers. No, when two officers in different grades or an officer and an employee are involved jointly in an incident and disciplinary proceedings are sought to be instituted, comma, a common inquiry is prescribed. Full stop. It is submitted that admittedly in the instant case, comma, no such procedure was adopted and thereby the entire proceeding against the petitioner would stand vitiated. Full stop. Para, with regard to the merits of the allegation, comma, it is submitted that the instruments in question, within bracket checks, were issued by other officers which also bear their signatures, and therefore the petitioner cannot be held guilty of any misconduct. Full stop. It is also submitted that the amount in question was refunded by the petitioner, and therefore the respondent bank did not suffer any loss. Full stop. Para, in support of his submission, comma, the learned counsel for the petitioner has referred to the following decisions. 1, 2, 3, 4. In the case of G. Dasayan has been cited in support of the plea that different punishments cannot be inflicted on similarly situated delinquents. Full stop. Similar, the case of Akhilesh Kumar Singh Supra has also been cited on the same aspect. Full stop. Para. In the case of Amresh Narayan Chaudhary Supra, a division bench had interfered with the penalty of removal from service of the incumbent on the ground that for a different incumbent against whom there were serious charges which were graver than those against the petitioner, comma, a lesser penalty was imposed. And on that consideration, comma, the matter was remanded back to the authorities. Full stop. The case of Nipun Rajbongsi has been cited wherein this court had remanded the matter for fresh consideration on the matter of infliction of penalty by taking into consideration the lesser penalty imposed upon a co-delinquent. Full stop. Para. Per contra, comma, Sri Dr. Delaney Senior Counsel has submitted that the allegation against the petitioner, who is an employee, who was an officer of the bank, are absolutely serious and grave, as the same pertains to misappropriation of public money. Full stop. It is submitted that such instance of misappropriation was not a solitary instance, but on 3 different occasions there were misappropriations. Full stop. By referring to the materials on record, including the memorandum of charge, comma, it is highlighted that on 14/2/2009, an amount of rupees 90,000 was misappropriated, comma, semicolon. On 21/7/2009, an amount of rupees 96,332 was misappropriated, and on 19/11/2008, an amount of rupees 5,87,675 was misappropriated. Full stop. It is submitted that all these amounts which were in the form of checks were deposited in the account of the petitioner maintained with the UCO Bank, which was opened on 11/12/2008. Full stop. It is submitted that so far as the check for the amount of rupees 5,87,675 is concerned, comma, though the same was issued on a prior date, comma, the same was held back and deposited immediately on the very next date of opening of the account by the petitioner on 12/12/2008. Full stop. In this connection, comma, the copy of the concerned check, which was also a copy of the concerned check, which has been annexed in this proceeding and was also proved in the inquiry has been referred to. Full stop. Para. As regards the contention of the petitioner that no cross-examination of the witnesses were allowed, comma, it is submitted on behalf of the bank that the petitioner was indeed granted the opportunity to cross-examine the witnesses, full stop. On the aspect of not allowing a legal practitioner to assist the petitioner, comma, the senior counsel for the bank has submitted that even the bank was not represented by a legal practitioner, and therefore there could not have been a vested right to have a legal practitioner representing the petitioner in a domestic inquiry. Full stop. On the contention regarding regulation 42, comma, the learned senior counsel has submitted that it is only a discretion granted to the bank which would be evident from use of expressions within inverted comma may, and that cannot be a ground to challenge. That cannot be a ground of challenge. Full stop. Para. In support of his submission. No, not it. The senior counsel, para करके हैं, lastly submits that the duties and the role to be played by a bank employee should be of the highest standard in terms of integrity and good faith, as they hold, as a bank holds the public money in trust. Full stop. It is also submitted that the allegation of misappropriation is a very serious allegation, and the quantum of such misappropriation may not be a relevant factor. Full stop. Para. In support of his submissions, comma, Sri Datta, the learned senior counsel, relies upon the following case laws. Number 1, 2006, 6 SSC 187, देख लीजिए हाँ. Number 2, 2007, 15 SSC 775, 3, 2008, 8 SSC 92, 4, 2020, 3 SCC 423. Full stop. In the case of Narendranath Supra, the Honorable Supreme Court has laid down that mere repayment of the misappropriated amount would not absolve the delinquent of the charges. Full stop. In the case of and Gangaraj, comma, the Honorable Supreme Court has reiterated the contours and scope of judicial review in disciplinary matters wherein such examination can be done only on the decision-making process and not on the merits of the decision. Full stop. In the case of S. N. Goel, comma, the following observations have been made which would have relevance in the adjudication of the present case. Para 41, quote kar dena. Para. The rival submissions have been duly considered. Full stop. Para. The contention of the petitioner regarding violation of procedures in the inquiry is to be examined first. Full stop. It is contended that the petitioner was not afforded an opportunity to cross-examine the witnesses. Full stop. The materials on record, including the averments made by the petitioner himself in paragraph 10 would, however, show that cross-examination was indeed done. Full stop. With regard to the assistance by a legal practitioner, comma, this court is of the opinion that when the bank was not represented by a legal practitioner, comma, the petitioner, the delinquent petitioner cannot claim as a matter of right to be given the said opportunity. Full stop. What ultimately requires is whether any prejudice was caused to the petitioner in defending himself in the inquiry, and the materials on record do not suggest that any such prejudice was caused. Full stop. The contention of the petitioner with regard to Regulation 42 does not appear to come to the aid of the petitioner in any manner. Full stop. Regulation 42 envisages a common inquiry. Full stop. Even if a strict interpretation is given, comma, the situation envisaged is only when two officers in different grades or one officer and one employee are involved in the same incident. And in the instant case, the number of personnel involved is more than two. Full stop. However, comma, even overlooking that aspect of the matter, comma, in the considered opinion of this court, comma, the aforesaid regulation only facilitates holding of a common inquiry and will not by any manner bar holding of separate inquiries. Full stop. Para. The allegation against the petitioner is of misappropriation of bank's money, which without any matter of doubt is a grave and serious allegation. Full stop. The petitioner, who was an officer of the bank, was dealing with public money, and the doctrine of public trust would be wholly applicable. Full stop. It has been time and again laid down by various judicial pronouncements that discharge of such duties are in the fiduciary capacity, wherein utmost good faith is necessary. Full stop. There are instances when imposition of penalty are interfered by courts, wherein the allegations are of acting beyond one capacity as a bank's employee or certain procedural irregularities. Full stop. However, in cases where the allegations pertain to misappropriation, a strict approach is a mandatory requirement. Full stop. There are no materials on record, and neither is the case projected by the petitioner that the charges are without any basis. Full stop. The defense tried to be projected that the petitioner did not have any role, and it was the other officers who were involved. Does not appear to be an acceptable defense, inasmuch as all the amounts mentioned above were credited in the personal account of the petitioner maintained with the UCO Bank. Full stop. Though the amounts were deposited on various dates, in the years, various dates, namely 19/11/2008, 14/2/2009, and 21/7/2009, the amounts were deposited only on 29/11/2010 and 1/12/2010. Full stop. If the petitioner was actually not involved, such refund should have been made immediately on coming to know about the deposit in the personal account of the petitioner, which was not done. Full stop. The subsequent act of the petitioner to refund the amount after a lapse of considerable time cannot absolve the petitioner of the charges leveled against him, which is also the law laid down by the Honorable Supreme Court in the case of S. and Goel Supra. Full stop. Para. The case laws referred by the petitioner will not come to the aid of the petitioner inasmuch as in the present case, comma, it is the culpability of the delinquents involved which had determined the penalty imposed. And in the instant case, comma, it is the petitioner who appears to be to have played the pivotal role in the misappropriation of banks or misappropriation of the three amounts concerned, which were credited to his personal account in the UCO Bank. Full stop. Para. In view of the aforesaid discussions and by following the guidelines laid down by the Honorable Supreme Court, comma, this court is of the considered opinion that no case for interference is made out as the penalty imposed appears to be reasonable and commensurate to the charges which have been proved and established in the departmental inquiry. Full stop. Writ petition accordingly stands dismissed. No order is to cost.
Obliged.
Mr. Narjari, you are waiting for long which matter?
And for my lord.
For next matter? Huh? Next thing. If you want to, we can do your matter. What is the matter? Item
My
4?
lord, 4 to 8 matter.
4 to 8.
Analogous matter.
Okay, what are these matters?
My
That
lord,
one?
illegal appointment of A&M, my lord, in BTC area, my lord, without interview, without, my lord, written test, without preparing merit list.
Who are you?
My lord, we are also experienced, my lord, and initially working, my lord, at fixed pay, my lord, under,
You
national-
participated.
my lord, but not question of participating, my lord,
Did
because
you
there was,
participate or not?
my lord, only.
There was no recruitment.
Only, my lord, we submitted our document, testimonials. There was no, my lord, written test, so my lord, question of participation does not arise, my lord. No written test, my lord, no.
How was the
interview.
selection made, Mr. Musari?
They are all participate, my lord.
Huh?
They are all participate.
Participated.
Participated when I submitted the document.
So
How
there
did
will-
how did you conduct the selection? How
Walk
did
in
you
interview.
appoint?
Walk in process, my lord.
Hmm?
Walk in process.
Walk-in interview.
Walk in interview.
Okay. You did not go
APTP in item number 5, already filed.
as in file. That will cover the other cases also.
Yes.
Yes,
Well-
you had walked, there was walk-in process. You did not walk in.
My lord, walk-in, my lord, only submission of document. Nothing else.
No, they have, Mr. Musari said that you were supposed to go there,
Well,
face the interview
my lord,
and participate in the process.
Total 426 candidates.
my
appeared.
lord, we were
Out
not,
of-
my lord, a call, my lord. My lord, only advertisement says that, my lord, there will be walk-in interview.
Yes.
That is the
How many
advertisement.
participants were there?
426, my.
426 could participate, you did not. Why?
I don't, my lord, in the what the record says, my lord.
You are a resident of which place?
My lord, 5 is 4 to my lord is 8. My lord, if you lordship take the
You are
aid,
a resident of which place, which
my lord,
location?
Copenhagen district.
You don't know that 400 some candidates have joined, have gone in for the interview. You do not know.
No, not my. My lord petitioner, my lord, 36 in number, in the item number, my lord,
Well, Mr. Musari, how many participated?
426.
420. How many are selected?
56.
56. Large participation. Difficult. What is the post? ANM.
ANM, my lord.
Difficult. What is your answer? That 426 have participated. Is there any answer?
My lord,
You cannot deny matters of facts. If you deny, we will not be able to adjudicate.
my lord, we are
How
not
many posts
aware,
were there? 56.
we are not aware, my lord, how many participated, my lord,
See,
because
that has come from him. Why
Yes,
should we
yes,
disbelieve it?
426 only.
So we may not be able to grant Mr. Nardari any relief.
The attendance sheet mark not available.
Not only marks, he's got an attendance sheet also.
Attendance sheet of the
If it is manufactured, we do not know.
my lord, we were not called, my lord, no any, my lord, interview.
He must have gone somewhere at that time for expedition, for adventure.
My lord, only we went and submitted our documented.
Thereafter, you have gone somewhere else
No, my,
for travel.
no, my.
If 400 plus candidates could have participated, why not you? And why should we reopen the entire process for you?
The petitioner in my lord, 49 in numbers, my lord, they were not called, my lord.
Where is the advertisement?
My lord, page 86, item number 8, my lord, page, item number, item number 8, my lord. This will
WPC?
cover all the cases.
WPC?
WPC, my lord, is 3296.
3296. And where are your records, Mr. Musari? Where you get the, it just gives the dates. No, dates. When was the advertisement?
Advertisement date, my
Advertisement date is there, my lord, page 86, annexure 4, dated 22nd of November 2017.
22/11.
Yes.
Yes.
17. Advertisement for ANM.
ANM.
How many posts?
My lord, other posts are there, but
35.
35 posts.
And
Other posts also.
Other posts are
Other what posts? You are only concerned with ANM.
ANM. Initial, my lord, qualification was prescribed HS pass. Subsequently, my lord, we filed earlier petition, there, my lord, relaxed to class 10. This is the corrigendum issued, my lord. And kindly see the merit list, my lord. They are saying, my lord, that there was a test and everything was there. Kindly see, my lord, next page, that is page 88, annexure 6, this is the list, this is the select list. Only, my lord, roll numbers are mentioned there.
When did you mention, when did you submit your candidature?
My lord, according to my lord, my lord, advertisement we submitted, is my lord directed. The date, my lord,
But your case is that you are never called for interview.
no.
What does the advertisement stipulates?
Statement of walk-in interview,
What
my
is
lord.
the language employed?
My lord, advertisement says that, my lord, there will be a walk-in interview on 7th and 8th December 2017 at 10 a.m.
7th and 8th December.
7 and 8 December
17?
2017.
Oh, date of, at time?
Time at 10 a.m. onward.
Oh. Venue?
Venue, my lord. Dhenumar CSB office,
Silicon Board.
DLR building, Kokrajhar,
CS,
Central Selection Board.
Sales Selection Board office, DLR building.
why didn't you go on 7 and 8?
Okay.
Did you go on 7 and 8?
No, my lord, we submitted.
No,
prior to
it
that.
was given 7th and 8th walk-in interview. Did you go on 7th and 8th?
No,
Why?
Yes.
no, my lord. Prior to that, my lord, we submitted our application, not.
If there is a walk-in interview which is stipulated in the advertisement itself,
No.
you are not supposed to go there, or you are expecting some other call letters.
My lord, we are expecting, my lord, this, my lord, a candidate was interview, or my lord, because so many candidates were there, my lord.
Have you read Oliver Twist?
Sorry, my lord.
Have you read Oliver Twist? Have you heard of Oliver Twist? Somebody called Oliver Twist. No.
My lord. Sorry, my lord.
He asks for more. It's not enough. Walk-in interview is not enough. You need a call letter. Then tomorrow you might say that I need a vehicle to reach the place.
There were several aspects of there, my lord. They advertise.
If you do not appear, in spite of the stipulation that there will be a walk-in interview on 7th and 8th, how can you agitate your right? What right do you have?
My lord,
If you participate, not considered, matter would have been
They are only
different.
appeared with the leave of court, my lord. In WPC 7555, item number 5.
Item 5, what is it?
7 double,
What is it? Please give it up.
7 double.
Okay, we can close this, or we'll dictate at 2 o'clock.
my-
Mr. Narjar, you will record your name. You did not bother. And we don't want to dismiss in your presence.
with my permission, before lordship, that there are no also merit list prepared. No merit list was prepared.
Okay.
In page 88 is the select list. lordship.
Mm.
Some rule numbers are there. Rule number of 56, my lord, candidate, and post advertise, my lord, 35 only. And they, my lord, selected, total selection 56, and all 56, my lord, appointed. But for not advertised 56, my lord, only 35. Only 35. So, my lord, this page 88, this is the this is not merit list, my lord. And on the basis of such merit list, appointment was made. And there is no mark system to, my lord, assess that what mark the candidates got, my.
Yes.
My lord, and this selection, my lord, not supported by any service rule. My lord, I have commissioned that BTC has no any service rule, and they have not even adopted, my lord, this rule framed by the government of Assam, my lord. I have, my lord, annex 1 notification issued by, my lord, the government of Assam. Principal Secretary to the government of Assam.
Page.
Yes, my lord. Page 98, Annex 12. Office Memorandum 16 October 2004. Whereas in pursuance of the memorandum of settlement reached between the government of Assam, government of India and Bodoland BLD on 10th February 2003 in New Delhi in the presence of the Prime Minister, Deputy Prime Minister of India, it has been agreed to create BTC within the framework of amended 6th schedule, the Constitution of India. My lord, next page can you see this H, my lord, point number 8, in the page 99, in the page 2. BTC shall be competent to make appointment on all posts under its control in accordance to the rule of appointment followed or prescribed by the government of Assam. The council shall constitute a selection board for appointment to be made by it and shall also make rules with the approval of the government of Assam to regulate appointment. All circular relating to the filling of the vacancies and appointment issued by government of Assam from time to time shall be followed fully. However, the post where recruitment is to be made on the recommendation of APSC shall not be covered under this provision. So, my lord, this provision also they not comply because the BTC neither they have their own rule, neither they follow any rule, my lord. While my lord, this type of selection, my lord, they adopted. Because my lord, selection in service, my lord, matter, especially government, my lord, there must be written test, interview test, and merit list. Except my lord, military and paramilitary, there also my lord, physical test, medical tests are there. And in private sector only, my lord, this type of interview allowed.
Where is the advertisement?
Yes, my lord. Advertisement page 86. The Central Selection Board, Voluntary Territorial Council, Kokrajhar invite eligible candidate for appearing in a
Regarding,
walk-in interview.
Vacancy, my lord, here is clear mention about
Yes, we have seen that. We'll come to you.
the number of vacancy of the post may likely to increase or decrease subject to approval of DC at the time of declaration. And here mention first page.
Yes, yes.
Our is, my lord, D category of post of ANM. ANU, my lord, CSB office, dated 7 and 8 December 2017 from 10. Number of post 35. 35, Roman 1, 35. Qualification, HS pass in any stream, diploma, ENM, and government recognized training institute and register under Assam Nurse and Midwife Health Visitor Council. Age minimum 18 and maximum 43. SC, ST candidate as per government norm. My lord, HS qualification subsequently, my lord.
Those we have already taken care of. We have taken into consideration. Anything new?
Basically, my lord, we select my such type of advertisement and my lord selection list.
Yes.
And I pray for my lord, a fresh my lord process, my lord, to be taken so that my lord, everybody will get a chance, my lord. Otherwise, it will amount to violation of Article 14, my.
My lord.
Because my lord, 35 number of posts advertised, and they, my lord, fill up 56 number of vacancies.
Mr. Musari, for whom?
PTC.
Okay, no, okay, okay.
My lord, as per advertised, oral interview was conducted and mark was distributed in 3 parts. General knowledge 10 marks, total 25, general knowledge 25, intelligence
General knowledge,
10,
10,
IQ 10, and personality 5.
and
Personality
personality, 25.
25 total. And all the mark
That means total is what? 45 marks.
25, 25,
No, personality, how many marks? 5 marks.
5 marks,
Oh, 5.
5,
Oh, total 25.
total 25. And all the 4 reports are available.
Okay.
And the petitioner appeared in interview, the attendance sheet are already available.
They had
Here
appeared.
appeared, but already appeared.
My lord.
Let's see.
No,
Krishna
my
was-
lord, and whatever my learned friend submitted, my lord, is not mentioned in the interview. What will be the pattern of mark? Nowhere, my lord,
But
mentioned.
you have appeared.
Let's see. Krishna Boro, it's item number 2, petition number 1. And Kondona, the repeat.
Where is your bona fide, Mr. Chauhan?
Kondona.
You appeared in the interview, took part. On your own mission, you said that you have submitted your papers.
My lord, this seat, my lord, not my lord, signed my lord by any officers, my lord. No way. Only my lord, some signatures are there. But my lord, in whose presence, my lord, who was the authority, my lord, in no way mentioned.
Marks, there are
No, my-
another mark.
the first tick, it is not mentioned.
Attendance.
Okay. Anything else, Mr. Musari? Yes, sir. Your numbers? 4 and 5 now. 4
4 to
to
8.
8. 4 and 5 now.
My lord, I am relying 3 number of judgment.
Yes.
My lord, the first one is the paragraph, especially 21
one?
and
Which one?
my lord, division bench, my lord, read appeal, my lord, 337 of 15. Paragraph 21 and 22.
Please read.
Yes, please. First, my lord, paragraph 21. The Honorable Supreme Court in case of Praveen Singh versus State of Punjab reported 2008 SBC had observed that there is always a room for suspicion for the common appointment if the oral interview is taken up as the only criteria. Though the interview undoubtedly is a significant factor in matter of appointment, it plays a strategic role, but it also follows creeping in a lacuna, rendering the appointment illegitimate. Obviously, it is an important factor, but ought not to be sole guiding factor, since reliance thereon only will lead to sabotage of purity of proceeding. Para 22. In the present case, illegality is writ large, and it is so glaring on the face of the having recourse to resolution of status so and so, which is termed as undeserving factor in the respondent number 7, evidently not in accordance with the principle governing the selection process, which is wholly impermissible under law. Therefore, in our considered view, extraneous consideration has played a prominent role in the matter of selection of respondent number 7, a candidate who performed so poorly in the written test and was made qualified, selected, and appointed by taking recourse to a procedure not supported by any service route. Thus, we hold that the selection and appointment of respondent number 7 solely on the basis of mark opinion variables is totally illegal and unsustainable.
Yes.
Next case, my lord, is 1998 9 SCC, page 104. State of Bihar versus Social Procurement, paragraph 3, 4, and 5. A few admitted facts are sufficient for disposal of this retributive recruitment to the class 3 post in several categories in the state of Bihar was advertised by the Bihar State Selection Board. Large number of candidates applied for selection. There were 1,005 posts in all, initially 978, subsequently 127 posts were included for 7 categories of posts. Special educational qualification for graduation with commerce, science, economics, and mathematics has been prescribed. For 3 categories of posts, only general education qualification has been prescribed. All are required to have graduated degree in a minimum qualification before selection of candidates. The pay structure, some of the posts underwent a drastic change, some of the posts carrying higher pay scale prior to the advertisement were of a lower grade with a lesser scale of pay, while some of
Okay, we have read. We have read last part. Merit list, without preparing merit list, you cannot make appointment.
third is also there, maybe.
Renu,
Yes, my lord, you know.
Genesis.
And one case from our High Court, my lord, decided by Honorable Supreme Court, case of Mukul Saikia, my lord.
Now, what is stated in Renu? Which paragraph?
Renu, my lord, paragraph 8.
8.
8. My lord, in fact, already discussed, but principle in 8. In order to render complete justice, we request all the selection appointment made for Group D post on the subordinate staff by the staff of the district judge. My lord, fact is required, my lord.
What is the law laid down?
Lord, my lord, this
What is the law laid down here?
my lord, Viva Voce, my lord, on the basis of only Viva Voce, my lord, or walk-in interview, my lord, this kind of appointment, my lord, should not be, because, my lord, it is, my lord, not, my lord, certain the merit of the candidate, my lord. But this is a government post, my lord.
Let him complete, will come to you. Yes.
Yes.
Okay. Anything else?
My lord, one more judgment is there.
What is this? What is the?
In case of
Ratio.
Mukul Saikia, my lord.
Yes. Yes. What is there?
Paragraph 44, my. It is well settled law that filling up the vacancy over the above, paragraph 44.
44.
Yes. It is a well settled law the filling up the vacancy over the above number of vacancy advertised would be violative of Article 14-16 of the Constitution of India. Here, my lord, 35 posts advertised and 56 appointment made.
Yes.
My lord, the petitioner, my lord, 42 in this case, and really, and 6 out of that, my lord, they got, my lord, job, my lord, under the government of Assam, my lord, under Directorate of Health Services. So their name is already deleted, my lord, 36 remain. And in
36 in all the lot. In all
all
the
in lot, my lord, 49. My-
total 49.
Yes, please. And 3200, my lord, 13 petitioners are there. And in this, my lord, is the 36 plus 13. So these petitions are there. Earlier, my lord, read petition not shown because, my lord, for my lord, subsequent development and subsequent filing of read petition, earlier read petition not necessary, my lord. Lordship may not take up.
Which one?
My lord, 370 WPC 7553 item 4 and then my WPC 1294 of 18.
Now, why these are not necessary?
Because, my lord, at the time prayer was, my lord, to relax the educational qualification. Because
5.
earlier, yes.
Item number 5.
Yes, earlier qualification, my lord, prescribed 8 years pass. Subsequently, they themselves, my lord, corrected, corrigendum issued, my lord, and they lowered to class 10.
Okay,
So, my lord, that prayer, my lord, already considered by
Yes,
the
in which items? Item number 5.
yes, my lord.
5.
5 WPC 7553.
That is item 5.
Yes. And next, my lord, WPC 1294. These two are, my lord,
Item 6.
we are not pressing.
Okay. Yes, anything else?
Judgment.
Hmm? Judgments?
Judgment.
On what?
Get up.
Okay. All these writ petitions being connected and related to a recruitment process for filling up of the post of auxiliary nurse cum midwife
My lord.
in the BTC are taken up for hearing together and are being disposed of by this common judgment and order. Full stop. Para. At the outset, comma, this court has been informed that so far as WPC so and so 5 and 6 are concerned, comma, no adjudication would be necessary as the grievance raised in those writ petitions pertaining to the minimum educational qualification has already been redressed in the meantime. Full stop. Para. The facts which are projected in the writ petition and relevant to the issue involved are that on 22/11/2017, an advertisement was issued for filling up of 35 numbers of posts, for filling up of various posts in the BTC, including 35 numbers of posts for ANM. উপর ANM এটা hearing of ANM. Full stop. The initial requirement of the eligibility criteria was higher secondary pass, which however was corrected by a corrigendum to be class 10 pass. Full stop. It is the case of the petitioners that they had submitted their candidatures and in terms of the said advertisement, full stop. However, comma, they were never called for the selection procedures, and accordingly, they were deprived from a fair opportunity in public employment. Full stop. The challenge is also based on the fact that no merit list was prepared and the selection was apparently based only on viva voce. Full stop. The aspect of filling up more posts than those advertised, than the numbers advertised, has also been raised. Full stop. Para. I have heard Sri B.B. Narjari, Planet Senior Counsel, assisted by Sri Chauhan, learned counsel for the petitioners. Full stop. The BTC authorities are represented by Sri R.K. Musahari, the learned standing counsel. Full stop. Para. It is submitted on behalf of the petitioners that as per the advertisement dated 22/11/2017, comma, the number of vacancies in the post of ANM was clearly reflected as 35, whereas the appointments were offered to 56 numbers of candidates. Full stop. It is submitted that the petitioners were not given any call letters and therefore they could not participate in the selection test, which otherwise also is not in accordance with law, as it was consisting only of viva voce. Full stop. It is also submitted that no merit list has been prepared and no marks obtained by the respective candidates were published. Full stop. It is also submitted that the selection was held without following any rules. Full stop. Para. Attention of this court has been drawn to an office memorandum dated 16/10/2004, as per which, the BTC was supposed to make rules for making appointments. Full stop. It is accordingly submitted that the selection and appointments are liable to be interfered with, and a fresh selection be directed to be made by giving the petitioners a fair opportunity of participation. Full stop. Para. In support of the submissions, reliance has been placed upon the following case laws. Number 1, 2009, 1 SCC 386 Mukul Saikya Rekilaba. Number 2, number 2 hobo. Number 1 hobo. 1998 9 SCC 104 State of Bihar. Second to hobo 2009, correct? Third to hobo 2014 15 SCC 731, and last to hobo order dated 19/10/2023, passed by this court in WA 337 2018 within bracket DB. Namhul Dipankar Dihengia. Full stop. Para. The case of Mukul Saikya Supra has been cited on the aspect of filling up of more vacancies than those advertised. Full stop. To second of Mukul to first to 90 Bihar বলেছে। In the case of State of Bihar Supra, it has been held that selection and appointment without preparation of a merit list is violative of Article 14 of the Constitution of India. As next Mukul se kya hibo? Renu to police lage. In the case of Dipankar Dihingia, a revision bench of this court has held that selection and appointment is not generally to be done on the basis of oral examination only. Full stop. Para. Per contra, Sri Musahari, the learned Standing Council has submitted, has questioned the locus and competency of the petitioners to raise the present issue itself, full stop. By drawing the attention of this court to the advertisement dated 22/11/2017, comma, the Learned Standing Council submits that it was clearly stipulated that it would be a walk-in interview, inverted, wherein all details of such interview was stated, full stop. The dates for interview were given as 7th and 8th of December 2017, semicolon, time as 10 a.m. and the venue as the Central Selection Board, comma, DLR building, full stop. Para, with regard to the contention that no select list has been published, comma, the Learned Standing Council has submitted that the petitioners have themselves admitted that a list was indeed published of 56 candidates, full stop. He submits that though the names and other details were not notified, comma, the respective roll numbers were clearly notified, full stop. With regard to the submissions that the selection was held without any rules, whereby reliance has been placed upon the office memorandum dated 16/10/2004, comma, it is submitted that by the said office memorandum, comma, the BTC was held to be competent to make appointments, full stop. The Learned Standing Council has it is further submitted that the selection was made through a duly conducted recruitment process, wherein the oral examination had 3 aspects with different marks, full stop. For general knowledge, comma, 10 marks. For general knowledge and IQ, comma, 10 marks each were allotted, and for personality, 5 marks. And accordingly, comma, the selection was done, full stop. Para, the Learned Standing Council has submitted that the records would reveal the marks allotted to each of the candidates, and what is more striking is that the petitioners had actually appeared in the said interview, and this fact has been totally suppressed in these proceedings, full stop. The Learned Standing Council has also produced the attendance sheet of the said interview process. Full stop. As regards the aspect of making more appointments than the vacancies notified, comma, the Learned Standing Council has submitted that the advertisement itself had clarified that the notified vacancies of 35 posts were likely to be increased or decreased depending on the situation, and accordingly deselection and appointments were made. Full stop, para. The Standing Council has also submitted that the petitioners, having participated in the selection process and had emerged to be unsuccessful, cannot turn around and challenge the same. Full stop. In this regard, comma, Sri Musahari, the Learned Standing Council, has relied upon the cases of Union of India versus S. Binod reported in 2007, 8 SCC 100, and Amlan Jyoti Borua versus so-and-so reported in 2009, 3 SCC 227. Full stop. Para. The rival submissions have been duly considered. Full stop. The advertisement dated 22/11/2017 had clearly indicated that it would be a walk-in interview, inverted comma, and being conscious of such procedures, comma, it is the admitted case that the petitioners had submitted their candidatures. Full stop. As observed above, the aspect of educational qualification was already rectified by the corrigendum, and therefore there is no existing grievance on that aspect. Full stop. The advertisement clearly stipulated the dates, time, and venue of the walk-in interview, which have been stated above. Full stop. Though the vacancies were notified to be 35, comma, there was a clear stipulation that the same was likely to increase or decrease. Full stop. The total number of appointments made is 56, and the contention that no merit list was prepared is belied by the document annexed in these proceedings, containing 56 roll numbers of the selected candidates. Full stop. The Learned Standing Council has also highlighted the aspect as to how the oral test was held on marks allotted to different aspects of general knowledge, comma, IQ, and personality. Full stop. The marks allotted are also available in the record produced by the learned counsel. Full stop. Para. What is more intriguing is the submissions made by the learned standing counsel, supported by the attendance sheet, that the petitioners had in fact participated in the walk-in interview. Full stop. The petitions, there is an admission in the petitions regarding submission of their candidature. Full stop. However, the non-disclosure that the petitioners had participated in the interview amounts to suppression of material facts. Full stop. In any case, the challenge which are structured on the grounds mentioned above does not appear to be substantiated or based on the materials available on record. Full stop. The case laws cited by the petitioners would not come to their aid, as this court has noticed that a merit list was indeed prepared, based on which the appointments have been made. Full stop. The filling up of more posts than those advertised, than the numbers advertised, was a stipulation in the advertisement itself, and therefore would not be a ground for interference. Full stop. In the case of Dipankar Jihingia, relied upon by the petitioner, there is a clear finding in paragraph 22 that the private respondent therein had performed poorly in the written examination, and in that context, the decision was rendered. Full stop. Para. The aspect that the petitioners had indeed participated in the selection procedure is a relevant and important aspect, and accordingly, their locus to challenge the selection process after they are unsuccessful is itself questionable. Full stop. Even if it is assumed that they had not participated, what is admitted is their candidatures being offered, and there being a clear stipulation in the advertisement itself regarding the dates, time, and venue of the walk-in interview, the contention of the petitioner that they were not given any call letter is not acceptable at all. Full stop. Para. In view of the aforesaid facts and circumstances, this court is of the considered opinion that no case for any interference is made out, any interference with the selection and appointment concerned, appointment initiated by the advertisement dated 22/11/2017 is made out, and accordingly, all the petitions are dismissed. Yes. What is this?
There was a penalty, Your Lordship.
PHE, Mr. Gogoi was
Mr.
roaming
Gogoi
around.
was here. I think Gogoi had just gone on to call Mr. D. Gogoi.
Okay. What is the matter?
Yes. The matter here, Your Lordship, the challenge is to the office order at page 62. But before that, Your Lordship, the facts would be necessary, Your Lordship. If Your Lordship permits me to read the fact.
Now, what, just tell us. What
Yes.
is in brief?
The basic issue, Your Lordship, was that the petitioner initially was a skilled monthly rated worker with the PH.
Yes.
Thereafter, he was promoted as a Khalasi. In the month of March 1996,
Hmm.
he met with a electrical accident, sort of an electrocution, Your Lordship. And thereafter, he was in medical leave till July 1999.
Yes.
Yes. He
Then-
was paid his dues and salaries till the month of August 1996.
Hmm.
And thereafter,
Hmm.
till this writ petition was initiated, he was not paid a single penny. We approached this honorable court on 2 occasions
Earlier.
earlier. The first occasion, this honorable court directed the authorities to undertake an evaluation of the case of the petitioner and thereafter do the appropriate, the needful. What is also relevant, Your Lordship, is that in the midst of this all, in 2003, I was regularized as a Khalas. The stand of the government, Your Lordship, is that after the month of August 1996, where I was permitted to be on leave due to my medical condition,
Hmm.
I did not report on duty through and throughout.
Hmm.
And the department has also sought and stated that the medical certificates which I had furnished before them were photocopies and that I need to furnish the original document. That is the case of the respondent.
Hmm.
Based on that, they undertook a fresh departmental inquiry in the year 2013.
Hmm.
The show cause was served to me on 13/3/2014, and thereafter I was terminated on 2/7/2014. Retrospectively, from 1/8/1996, when my supposed medical leave of absence ought to have expired as per the department. This is besides the fact, Your Lordship, that in 2003, I was regularized based on a man in position survey undertaken by the authorities there. That is the gist of the matter. The other fine aspect in the matter, Your Lordship, is that the show cause was followed by an ultimate order, the final order which I've challenged, without resorting to the procedures laid down in Rule 9. That is one part of the matter. The second part of the matter, Your Lordship, is that the authorities have sought to investigate my absence from 1/9/1996 because the termination has taken effect from that period. The departmental inquiry was initiated in the year 2013. So the other aspect before Your Lordship, subject to what Your Lordship determined, is that whether there was a delay in initiating the departmental procedure. And the third aspect, subject to what
Procedure is not followed.
procedure is one part of it that I've stated, Your Lordship. But beyond that, beyond the aspect
What
of
procedure was followed?
the procedure, Your Lordship, was a show cause which was given to me. I had replied to the show cause,
Yeah.
and thereafter, the order of penalty was imposed on me, which is
Inquiry?
at page 62.
Inquiry?
No.
No inquiry.
No inquiry. It is their admission.
No inquiry or inquiry where you did not participate?
It is their claim. It is in fact in their affidavit that they've stated that the postal remarks have come back as not delivered
Okay.
on 2 occasions. I have to be fair before this court. On 2 occasions. And
No,
thereafter,
no, yeah, your non-participation is another aspect. Was an inquiry held or not?
the inquiry was purportedly held behind my back without my
My
But that,
submission,
those are different facets.
Yes,
We'll
yes.
examine.
yes, yes, yes,
Even that aspect, if you have been deprived of participating,
yes.
and you might have chosen not to participate, those are entirely
Yes,
different
yes,
aspects.
yes,
But not participating may not absolve them or
yes,
make it a case that where inquiry is not required.
Yes.
If the inquiry was held,
yes.
charges have to be proved.
Charges have been proved. Again, without, yes, charges have been proved. There are
Then-
four charges which have been laid down.
Second show cause notice given to you.
The show cause, no. The second show cause notice, your lordship,
Yes.
no.
What do they say?
They say that, your lordship, the fact that I had in
That
there,
was- they contend that it was given to you or not.
they stated that they had given to me, but that the postal receipt came back as not delivered to me. I was not aware of that.
Second show cause.
Second show cause. I was in fact given summons to visit for inquiry pursuant to the show cause. The show cause I have responded to. Thereafter, I was
Where is your residence?
my residence, sir.
Which office did you work?
My residence is at in a village, Noornagar, Katriali, Katigora, your lordship. That is I'm a local resident.
Katigora in Karimganj.
Kasar.
No, no, my lords. Direct way. And my lords, as we descend from
Yes.
Meghalaya, my lords, that area, though it's in the vicinity to Kasar, it falls in the district of Karimganj. It's Katigora.
Katigora is.
Yes.
Karimganj.
Yes, man, that's Katigora, my lord. Just below that.
No, but did you serve him the second show cause notice?
It was served, my lords. It was served. There was a postal endorsement also.
You abided by the procedurals.
My lords, it was abided. My status is as regards my affidavit.
That is on the part of the procedures. But on substantial basis, do you think that you have treated him fairly?
As per my instructions, my lord, the affidavit, yes, my lord, he was given a chance, my lord. He was
No,
given
but
two chances.
taking into consideration the
One issue, my lord, now perhaps my learned can like to point out, my lord, this person has expired.
who is one.
I have expired, but I have been.
You have not expired.
But
Petitioner will not come and say, no, I have expired.
Been-
There is a movie that his living certificate was stated.
Kagas, yes,
He was asking for pension, and where is your living certificate? You have to prove a certificate, give a certificate that you are living. So are you substituted?
Yes.
Substituted. Who are there?
In the month of May, all my brothers and sisters are not married. I'm unmarried. No issue.
Okay, so it's been kept alive. Issue is still kept
Yes.
alive. Yes, what can be done?
And
Still
also,
question of reinstatement, otherwise also is gone.
yes. Only question, my lord, whether the DP proceeding, my lord, to which he was, my lord, later on dismissed, my lord, was it flawed or not?
No, the procedural part is one part.
Yeah.
Even if he's not been able to make out a case, that procedures were violated, and we find that procedure more or less it was followed. Then what about the merits? He had suffered some
electrical shock.
electrocution.
Yes. I'm suffering from psychosis.
My lord,
But that is only a statement. We do not know the veracity. We cannot believe each and every statement. Nowadays it's difficult.
Right.
It's up to you. You are the department. You have seen the person.
Right.
At times, a small issue is blown out of proportion.
Right.
So we will not depend too much on his statement. It's up to you to make a call.
my lord, medical documents were asked for to
Did he
provide. my lord.
produce the medical-
He didn't produce, my lord. He only recourse he was taking that my medical documents in original are with my lawyer at Guwahati.
This is what he's saying. I'll make my.
Let him complete. Let him hear him out.
No, see, person has expired. We don't want to give too much of time. If you can arrive at something that you give something to the family members.
Yes, my lord.
Better
So
than-
perhaps, my lord, the what has happened basically since it's a dismissal. It's a dismissal. Rule 24, my lord, the pension gets forfeited. Perhaps for that fiscal benefit they are before this court.
My initial case was that for me to be reinstated.
How long did you serve?
I served your lordship till 2000.
Now, how long?
How long? I was yes. What was it?
1800.
I was initially appointed in 89, and thereafter I served till I was terminated.
When?
in 2014, 2/7/2014.
89, 19.
I was regularized in 2003 as a Khalasi. I was regularized. My name features, Your Lordship. That is after their claim that I did not attend my office.
No.
And on merits, Your Lordship, there's one submission I need to make. On merit, the authorities claim that I needed to produce my original medical documents. I have made a submission that I have attested my medical documents and I have sent them to the respondent number 6. A categorical submission.
Who is
And I have,
six?
respondent number 6 is Assistant Executive Engineer. I have made that submission numerous times for the authority that the original document, Your Lordship, is with the authority themselves. And my lawyer here, while agitating the earlier writ petition, was in receipt of the photocopied document. In this regard, Your Lordship, I just tried to explore my case to an extent, Your Lordship. The Indian Evidence Act, under 63, section 63, Your Lordship, it states that secondary evidence means and includes copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy and copies compared with such copy. Now, if I'm reading section 65, when the original has been destroyed or when the party offering evidence of its contents cannot, for any other reason not arising from his own default or neglect, produce it in reasonable time, secondary evidence may be given of the existence, condition, or contents of a document. I have done that numerous times before the authorities.
Have you served notice? If you talk about secondary evidence, we can put a number of questions.
Yes. No,
Where is your application? Ask him then to produce the original.
Yeah.
Don't just jump to the Evidence Act and read proceedings.
Yes. No, I'm trying
If you
to
do that, you'll be in trouble.
Yes, I'll try to explore my
You'll really be in trouble.
Yes.
Show us the application. What is the secondary evidence? Let us understand from you. What is 63?
Yes.
What is 61? What is primary evidence?
Because
What is 65?
No, because what the authorities wanted to ensure was that I provide them with
Simply saying secondary evidence will not do. There has to be an application.
Yes.
Original are with them. You
The
have to
original-
give notice to them. They are not producing. Then we can give them a direction, produce. Otherwise, they'll accept the secondary evidence.
In fact,
What is the value of a secondary evidence?
Your Lordship may kindly come to page 51 for a moment, Your Lordship. Page 51.
5-1.
Yes, Your Lordship.
What is this?
In fact, apologize, Your Lordship. Page 65 for a moment.
65.
65.
Yes.
This is the letter, Your Lordship, which is dated 16/8/2013. This is referred before the executive engineer, Your Lordship. If I may be permitted to read, Your Lordship. The third paragraph.
Yes.
That, sir, after the accident, which I had met while on duty on 30/3/1996, I had to seek leave on medical grounds, and from time to time, I made petitions for medical leave to the assistant executive engineer and had submitted all the original medical certificates by registered post with AD. And the said fact has been mentioned by me in my prayer dated so-and-so, addressed to you. That, sir, prior to submission, I had kept a copy of each medical certificate and had the same attested, but in October-November 2005, I had submitted the said attested certificates to the assistant executive engineer who had verbally directed me to do so for complying with the order of the Honorable Guwahati High Court in WPC number 4665 of 2005, and the said fact has been mentioned in my letter.
If it is lying with you, why don't you?
That is the only.
Was it lying with you?
My lord,
The assistant
no, my lord,
executive-
no, it was never with us.
Your Lordship.
We have the original records.
But did you verify with this?
No, Xerox.
Did you verify with this officer, assistant executive
Verified.
engineer?
Only Xerox were with us, my lord, never the original.
Not you, are you raising any doubts regarding the injury sustained by him?
No, that part can sleep. That I'm not, there is a medical report, my lord, but these are all in Xerox, duplicate. We had asked him for the originals. This is his own submission, my lord.
Let us see what are the medical documents.
Yes.
Which page?
Your Lordship will kindly take up the affidavit in reply.
Page?
Yes. Your Lordship, the running page would be 121. 121 onwards, Your Lordship. Annexure W series. This entire document, Your Lordship, pertains to the medical document of the petitioner.
There's a battery of doctors. Not a single lot of doctors. Okay, what was it? Wait. Very good. Okay, if we annexed W.
Where, these are all type copies.
Yes. Yes, Your Lordship. The true copies, Your Lordship, they start from page 145. 145, Your Lord. Running page 145.
Grammar practice.
110 or 100. It starts from there.
Mr. Gogoi, how do you resolve? Is there a way to resolve this without going deep into the merits and facts?
This,
The original petitioner has passed away.
And
even now also, if you can produce the originals, then we can take a call.
Now it will be too difficult
Too
or
late matter.
onerous upon the
Your
legal
Lordship,
heirs.
Your
Yes,
Lordship,
ma'am.
for a moment, Your Lordship, I implore Your Lordship to come to page 58, Your Lordship.
5-8.
58.
Private.
58. No, 50.
Yes.
58, Your Lordship, is the show cause which was served on me in 2014.
Hmm.
It takes into account
Yes.
page 59 is statement of allegation.
Hmm.
The
Yeah.
last point, Your Lordship,
Hmm.
you ought to know that even in a regular establishment, no employee can be retained by an appointing authority where the absence is 5 years or more. You ceased work about 3 times of that limitation. You are therefore charged with deliberate insistence in an illegal matter. This matter was initiated in 2014, Your Lordship. Subject to what Your Lordship determined, there is an aspect of delay here also which is attributable. There was no departmental proceeding which was contemplated earlier. The fact that this writ petitioner approached this court on 2 occasions and thereafter there was a direction from this court, the authorities construed the order of this court and they initiated a show cause in 2014 against my supposed absence in 1996, 1999. the aspect of delay would also play a material factor, your lordship, subject to what the lordship determine. And what is very relevant for your lordship,
Delay in what? Delay, it's not a court proceeding, it's their prerogative.
it's their prerogative, your lordship. but
The employer-employee relationships is not severed. Even if it is severed under the pension rules, one can have the permission and go ahead. Even after a person superannuates.
Yes.
Yes, this is something which was within their knowledge.
Yes,
That's a
yes,
different aspect.
yes.
You can
that is
very well argue that it
That
was
was-
within, it's not something which is suddenly emerged, that
Yes,
they have
yes.
detected something.
Yes.
Your absence was known to them, so they did not take any action.
supposedly known to them, and that was blatantly explored by the authorities.
Mr. Gogoi,
That is
what
why-
is in your court? Otherwise, we go for a, we do not know what will happen then.
Well, we have started tested everything in our affidavit, my lord, affidavit of opposition. And we have, we have paid him salary also, we paid him allowance also. And my lord says, conduct is, my lord, that you just produce the originals, that is not coming from.
No, now,
My question-
now that aspect of directing them to produce the originals,
It is.
that may not be too
Yes, my lord.
reasonable. What can be the possible resolution? How do you resolve?
Definitely can take it up with money type. Well, I could limit my submission only to the defending of the DP proceeding. Other materials are, my lords, not very relevant, in my opinion, my lord. Subject to correction. The DP proceeding, he says he didn't receive anything, but first show cause was there, which he has admitted.
Please, I reply.
Yes. And my lord, the issue is like, he was given opportunity, he didn't participate, my lords. Only that much, perhaps. If that DP stands, then everything stands, my lord. If that DP goes, he's entitled to everything. Because entire basis of the DP also, that medical cert issue was also taken into consideration, his absence and everything.
But then we decide the validity of the DP? Whether it's,
Yes.
yes, on the DP, let us hear, what do you have to
Yeah.
say?
Your lordship,
When was this thing, show cause?
the show cause, your lordship, is at page 58. 59 is a statement of allegation. Page 58.
58 is 13th March.
Yes, your lordship, 13th March 2014. The statement of allegation, your lordship, is at page 59.
This is show cause. Statement of allegation 59. Statement of allegation. Okay.
If I may permit to read the
What-
allegation, page
yes.
59.
Yes.
Oh.
Yes,
Yes,
please,
yes,
please,
yes.
please just,
Point 1, that you remained absent from duty since 1/8/1996 on plea of suffering an electrical shock while on duty as a work charge classee for a long time. Disregarding your service condition in a work charge establishment, you are therefore charged with deliberate absence. That you are asked to submit medical certificates in original to verify the fact, but you failed to do so repeatedly. Therefore, you are charged with submission of untrue statement. That you sometimes said your documents like original medical certificates are with your advocate, but you failed to show them as asked for. Therefore, you are charged with misrepresentation to misguide the authority. That the terms of your service in work charge establishment governs the principle of no work, no pay, but you repeatedly claimed your salary and allowances for the absent period. Therefore, you are charged with deliberate ignorance as to your own service rules and conditions. You ought to know that even in a regular establishment, no employee can be retained by an appointing authority where the absence is 5 years or more. You ceased work about 3 times of that limitation. You are therefore charged with deliberate insistence on an illegal matter. My reply, your lordship, to that letter, the show cause, is at page 60.
page
Page 60 is my reply, your lordship.
60.
60, your lordship.
Hmm.
It is dated 19/3/2014. 19/3/2014.
Okay.
With, if I may permit to read you,
This is, you have denied.
this is my denial. Yes.
Okay.
Number one, that the
Then it's
allegation.
okay, no,
Yes,
no need
yes.
to read.
Here, this is the letter which I referred to your lordship, stating that I had sent the original to the assistant executive engineer.
Where, which
The
letter?
paragraph number 3. That as regards para 3 of your letter, it is submitted that your humble employee by this petition dated so and so stated to you that the medical certificates in original have already been submitted to the assistant executive engineer in your office attached to his medical leave petition. As such, the certificates are lying in your office only. The Xerox copies of the same are lying with his advocate. Your humble employee never stated that original medical certificates are lying with his advocate. The question of misrepresentation or misguidance by the humble employee does not arise at all. As such, the said humble employee is not at all liable for any charge against him. That the allegations made in para 4 of your letter are humbly, totally denied by your humble employee. The poor employee never remained absent without the knowledge of the authority concerned. Whenever he remained absent, he used to inform the authority concerned supported by the original certificate. Other than the medical.
Okay.
Yes.
Then,
Number 5.
then.
Yes, yes. Then, your lordship, at page 62
Two.
is the impugned order, your lordship, of punishment.
You are not aware of what has happened in the meantime?
No.
Where are your statement in the writ petition?
Yes. Paragraph number 23. Paragraph 23.
20?
Page 13, your lordship. Page 13, paragraph 23.
Yes.
Yes. That the entire basis for initiation of the misconceived disciplinary proceedings stems from the alleged non-submission of medical certificates for the period of absence between June 1996 and August 1999, which is, as is evident from above, is unfounded and baseless and merely a pretext to dismiss the petitioner from his long.
Not on this, that
Yes,
something has happened
yes,
and you are
yes.
not aware.
Yes. Your lordship, paragraph 26 onwards, if I may permit it to read, your lordship.
26.
26 onwards.
Yes.
That it is submitted that the decision of the respondent authorities in initiating disciplinary proceedings against the petitioner is arbitrary, illegal, and malafide. That the impugned speaking order dated 4/12/2013 passed by the executive engineer was based on which the misconceived proceedings were initiated, holding that the petitioner did not submit the original certificates and therefore had been negligent unauthorizedly absent, betrays total non-application of mind of the fact situation in the
This is
documents.
not what we are asking, Mr. Sharma.
Yes,
Where
the
is going
process-
to irrelevant facts?
The process has not been followed, your lordship. The
Where is that?
Rule
You are
9,
not-
your lordship.
We are not aware of the note.
27. I would have read. Paragraph 27, your lordship.
Yes,
The last portion.
yes.
Yes. That the petitioner submits the consequent action of the respondent executive engineer in passing the impugned order of dismissal without following the mandatory procedure governing departmental proceedings as provided under Rule 9 of the 1964 rules must be termed arbitrary, illegal, and a gross abuse of executive power, not vested under law.
We are not on this expression in English language. We want a simple statement. I was not served notice. I did not know.
That is the only extent to your lordship.
Where is that?
Yes, yes,
That it was held behind your back. One line.
yes, yes.
You are not aware of it.
No, yeah, I'm aware, your lordship, I'm aware of that. Your lordship, paragraph number 20.
Till now you have shown 5 paragraphs.
Yes, yes, 19 and 20, your lordship.
Yes.
Yes, 19 and 20, I need to read, your lordship. Both the paragraphs, your lordship. The petitioner was never furnished with a copy of any inquiry report based on which allegations have been held to be proved to enable him to submit an effective reply.
Twenty.
Yes, 20, the last line, your lordship.
20.
Yeah. This is substantiated in the affidavit also of the authorities, your lordship.
Just a minute.
Yes,
please.
yes.
How is 20 answered? Who has filed the affidavit in opposition?
This
Mr.
is
Gogoi?
the executive engineer. my lord.
R5.
Yes, my lord. R5.
Let us see how we have answered 20.
It is a
Paragraph
page,
22,
yes, page 70.
77. Internal page 9. Have we answered? Reply to 20. Petitioner was informed about the
He was
appointment.
informed, my lord. The petitioner informed the appointment of inquiry officer. By letter number so and so, he was asked to appear to present his view, but the petitioner did not turn up.
Thereafter, what about the second show cause notice?
Second was also sent to him, my lord.
Now, where is your statement, Mr. Sharma? Regarding second show cause notice?
One of the- No, that's good. Zero, not sort of-
Your lordship is at page, internal page 9 of the affidavit in reply, your lordship.
No, where is your averment in the writ petition? Did you state anything?
10 to the. No, no, he-
The only instance, your lordship, of me receiving any communication was the show cause to which I replied, and thereafter the order of penalty.
No, that I well understood.
Yes.
20.
yes. Well, the one another aspect, my lord, the first show cause, he replied, my lord, into his allegation. The second show cause, my lord, he has to also demonstrate before this court what prejudice, assuming, my lord, not admitting also, even if it is not served upon him, my lord, second non-supply, my lord, this non-supply of that enquiry report or that show cause, what prejudice will be has been caused to him, my lord, because if it doesn't affect the finding, my lord, it is of no relevance, my lord. The ECIL judgment faced to my lord.
See, 20 and your reply at 22 are exchange of statements, denial. So how do you go about it? You said that you have not served with the notice of inquiry officer's appointment and the subsequent communication after the inquiry, not served with the inquiry report. They said that you have been served.
Everything was sent to postal. Postal endorsement was there, my lord. We have received reports from the postal headmaster also that we had inquired.
And what is also material is that these proceedings have come after the court's order. That means you were in the know that something is going on. And yet you are saying that you are not been served.
The last order, there are
Okay.
two court orders, your lordship. The last order, it is at page 55.
Hmm.
It starts at 54.
5-4.
54, your lordship, is the second writ petition. WPC number 1363 of 2013.
What was the cause of action?
The cause of action, your lordship, is that the grievance of the petitioner in the present petition is relating to non-payment of salary from August 1996 till date of that initiation of the writ petition. The operative part, your lordship, is the last paragraph. Having regard to the aforesaid submissions advanced, the writ petition is disposed of, allowing the petitioner to approach the executive engineer, PHE division number 2, Silchar, along with all medical.
Where is the, you said about regularization, where is the regulation
Yes,
of service?
yes. Your lordship will kindly come to page 30. Not page 30, your lordship, it is payment
Much
of
delivered.
page 34. Page 34. My name features at page 39. Page 34 is where the order starts. Your lordship has got it.
34 is
Annexure H.
date.
Date, your lordship, it is 24/12/2003. It's at the bottom, your lordship, signature.
24.
24/12/2003.
Thirty.
24. Page 34. Okay. 24.
At serial number.
Serial number 200, your lordship, page 39. Last name. And your lordship, this order of regularization was based on an earlier order, which is your lordship will find at page 40.
You have been brought under the regular establishment. The period as such nothing has been regularized of absence. Your services has been brought to the under the
Yes,
regular
yes.
establishment.
Yes. No, that has a bearing, your lordship. Why am I saying this? At page 40, page 40, the second,
Yes.
the thereafter, page thereafter.
Yes.
Page 40, in fact, precedes page 34. This order, your lordship, is to the executive engineer from the additional chief engineer.
Hmm.
It is stated that you are requested to verify the man in position individually before regularization. My status was verified by the authorities before I was regularized, your lordship.
No, you are not a man in position, admittedly. You are suffering.
No, 99 I rejoined. I resumed.
When did you rejoin? What is the date of your absence?
My absence was from 30
No, no, 1/8/1996
1/8/1996
to
No, my date of medical leave was from 33/1996, 33/1996 to 15/7/1999.
Hmm.
In the middle of that period, I was paid till 1/8/1996. Even during the medical leave of absence, I was not paid for the entire due.
You rejoined your service.
I rejoined my service
When?
on 16/7/1999. I was on leave till 15/7/1999.
Leave period?
Leave period is the intervening period from 33/1996.
13
33/1996. 33/1996
to
to 15/7/1999.
leave.
Yes.
And when did you sustain the injuries?
On 33/1996, your lord.
The date, first date.
Yes, yes, yes. Yes.
3 years you were on leave.
Yes. From
And
there
you're-
onwards, I was on leave.
You are paid up till
I was paid, yes.
August 96.
Yes. Payment of salary till August 1996. So I have not been paid thereafter since even after rejoining, and I was regularized, your lordship, in 2003. As per the assessment and verification of the man in position situation of the authorities, by the authority.
Mr. Goga, are you disputing that he had rejoined in 1999? 16/7. Let us see the so-called notice again at page 58.
Yes.
Till date. How did you, it's still date? How are you contending that you had joined in 1999? 58 says
Yes.
that you were absent from 1/8/1996
Yes.
till date.
That
Till
is
date
what,
means-
yes, yes. Your lordship will kindly.
Well, the question comes in, my lord.
Paragraph 30, page 32. Page 30 and page 32, your lordship will kindly see. Page 30 and page 32. This may not have a lot of relevance, but these are representations which have been forwarded by the petitioner for payment of the salary within the intervening period. That is the only material that I have on record to satisfy this court, Your Lordship, that I joined. I'm making a submission on behalf of the client.
Said,
I do not have
never
other substance.
Never did anything. Now, was the charge of unauthorized absence
Yes, ma'am.
for a brief, not a brief period, for a period limited from 1/8/1996 till a particular period of 1999, or is it till the date of issuance of this so-called notice? At
Till the
least
date of issuance of show cause, ma'am.
he never
No,
worked.
madam. He kept on sending letters.
This, what is also most striking is page 58, while addressing to the petitioner, you write, Workers Khalasi on unauthorized absence. They have treated you as being on unauthorized absence even on the date when this 13/3 was issued to you, page 58, Mr.
Yeah.
Gogoi.
My lord, 50.
On unauthorized absence.
My lord.
Let us see your pleadings so far, your resumption in duties and continuing thereafter.
Before that, Your Lordship, if I bring Lordship's attention to page 53.
53.
53.
Yes.
Your Lordship, this is a communication which has been forwarded by the additional chief engineer to the chief engineer regarding my application. Here, Your Lordship, it reads, the application of Muhammad Abdul Malik Borguia, Work Charge Khalasi, it's been written with a pen under suspension.
Yes.
That has been.
And that suspension was also not given to me ever. I was not suspended.
No, that is mistake, madam. That has been admitted. That was by mistake. No, that is by handwritten. That is admitted. That was mistake. That is a mistake. It should not be written like that.
ठीक है सर absent no.
I had to admit.
Where is the application?
Yes.
Earlier page.
Not earlier page, Your Lordship. The representation of by the petitioner is at page 28. 28. This has been forwarded at page 30.
Now, what about 53? This forwards what? Which application? Page 53 is only a forwarding letter, isn't it?
Yes, yes, yes.
Something has been forwarded. What has been forwarded?
Your Lordship will
I
kindly
think it's page
come to page 49, Your Lordship.
49 has been
Yes, yes.
forwarded.
Where the petitioner himself stated that kindly hold a fresh and a fair inquiry so that I be paid. It was my own admission, Your Lordship, before the government at page 49.
There are materials, Mr. Gogoi, at page 50 that he was in continuous employment and serving after joining. Page 50. And some read paragraph 3 at page 50. I joined my third line. I joined my duties
In the
in the office
yes,
of
this-
so-and-so
yes.
by issued by an order of 7/8, allotting my duties in store from 18/8. Subsequently, I was asked
Exactly, my lord. The other line, my lord. However, subsequently,
I was verbally, yes.
it's totally volte-face. He was asked to discharge his duty in storeroom without no substantiating materials. He says that I was asked by the SDO to go there. Even there's no proof that he had worked there also. These two lines are contradictory.
7, 8.
Muito, muito. And I
7. There is some, I think, error in expressing. It cannot be subsequent. Mr. Sharma?
in 7. It was earlier in time.
Huh?
Earlier in time.
No, it cannot be subsequent. So, what are you trying to express? Read the third line or fourth line onwards. Thereafter, read the entire paragraph. Paragraph 3 at page 50.
Yes, that after suffering from electric shock, as mentioned above, with effect from so and so till so and so, I was certified by the concerned doctor fit to resume my duty. Accordingly, on 16/7/1999,
Hmm.
I joined my duties in the office of the Assistant Executive Engineer, Silchar Subdivision 1, Silchar. Thereafter, the said Assistant
You
Executive.
joined on 16/7, okay?
Yes.
That is your, then on, thereafter, on.
Yes. The said Assistant Executive Engineer issued an order dated 7/8/1999, contained under so and so, allotting me duties at Silchar PHE store section with effect from 18/8/1999.
Hmm.
However, subsequently, it ought not to have been subsequently. I was verbally asked by the SDO to perform my duties in my earlier place, where I joined my duties on 16/7/1999, considering my injuries sustained due to electric. On the aspect of bona fide on part of the authorities, because the petitioner had suffered electric shock, cannot also be ruled out. My attribute to come bona fide to the authorities, Your Lordship, that I was treated fairly by the authorities. Beyond that,
Now, how did you bring him under the regular establishment?
in 2000,
2003, my lord, perhaps that
That is your,
consequently, my lord, perhaps.
that is your action.
Upendra's maybe perhaps, my lord. There's a only subtle explanation that out of sympathy, my lords, we had brought him under.
No, that is not the loan case of the petitioner. He is on, along with 199 others.
My lord.
His serial number is 200.
So connected to this case, the PhD department hadn't conducted an exercise, my lord, a vast exercise of bringing people on establishment in 2003. Not only,
No, immediately you should have rectified that. No, he is not working, so he is not entitled.
my lord.
It might happen that while making a general exercise, his name is also included in the list. But you never took a different stand. Well, you have the original records regarding the proceedings that it was sent.
Yes, my lord.
You
we have-
say you are making some submission regarding the postal department's
My lord, we have.
endorsement.
We have
Let
these
us
type.
see, let us see.
Take my lord. And one question comes, my lord, since my lord, he was regularized in 2003, that service period, 2003 comes in a regular establishment, and till 2003 he was in this master role. So these two are service are two different kinds of service, my lord. So if any benefit comes from that, 2003 will count him differently.
No, we are not on the benefits.
Right.
We are examining the aspect of the correctness, legality of your discharge, this removal.
Dismissal order.
Dismissal order.
Result 14 meter, my lord, we could read just 2-3 days back.
Delivered. When did the original petitioner pass away?
Your Lordship,
26/4/2018.
You are a Khalasi.
Work
You
charge,
were a
I
Khalasi,
work-
work charge.
Work charge. Alas, okay. Earlier I was key monthly rated worker.
Now,
Your Lordship. The question-
so otherwise you would have been entitled to some pensionary benefits.
if regularized, my lord,
He was regularized in
Yes, if-
2003.
following the dictum of Sanjita Roy, my lord, after deduction, he might have.
He is not, he would not have been in the ambit of Upendas.
Right.
Upendas is on a different aspect.
Yes, my lord. Upendas actually was not regularization, my lord. It was just
Upendas
for-
gets a minimum pay.
Yes, my
For the
minimum.
time they serve,
Right.
they are not entitled to regulation. Now here, there is an order of 2003 bringing him under the regular establishment.
Right.
So he might be getting the
Post-
post-retirement benefits, would have. Now there are materials, Mr. Sharma, that the notices were served upon you.
Your Lordship, there is another aspect here. that-
Where is the inquiry proceeding?
Inquiry-
Everything is black. It is with flag, my lord.
Huh?
I've used yellow color flag.
Your Lordship would kindly see one aspect here.
পিছফালে কিবা দি দিলে হ'ল আমি দিলে হ'ল কিতাপ এখন দি দিলে হ'ল বা কিবা এখন হেৰি দিলে হ'ল আৰু অলপ আৰু লাগিব হোৱা নাই আৰু লাগিব অলপ হৈ যাব হ'ব ঠিক আছে
But it would take.
You have the inquiry proceedings, how he had proceeded?
That is also flag, my lord. Everything is in that record, my lord.
614. Yes. Hmm. Fifty-five. Then 55. When was the, any idea when was the second show cause notice issued?
my lord, 10-4. 10-4-2014.
10-4.
My lord. He was informed that the inquiry committee has been formed now,
Okay, 10-4.
2014.
After his reply on 19-3-14.
Yes,
10-4, you issued the second show cause notice.
second.
In the meantime, you had finished the inquiry.
No, my lord, he was asked to participate in inquiry. He was asked to appear before the inquiry officer. That these are the allegations. We have received a reply. Now you come and appear before the inquiry
Now,
officer.
what is, from which date effectively he is making out a case that he is not aware, he was not aware of the further proceedings?
The petitioner says, my lord, the second he didn't receive. My lord.
When was the date?
Just exit.
Roundabout. When was the impugned penalty?
Penalty, my lord, that
Page 62, Your Lordship.
Date
2/7/2014.
2/7.
2/7.
2014.
Penalty of?
Penalty of dismissal.
I mean, there's another show.
Retrospectively.
Just a minute, just a
Yes.
minute. 2/7/2014.
Yes. Yes.
And subsequent to that 10-4, and after the inquiry report was submitted, my lord, this person was again proposed again on 16-6.
Hmm,
16-6.
he replied.
This he says it didn't. My lord, he doesn't reply, my lord. No, he doesn't reply to the letter number. But he replies to that also, my lord. 16-6 reply, he replied.
He had replied to
Yes.
16.6. He had replied on 26.
My lord, 26 is replied. 26 2000.
He says, Sharma, there is a reply from you. And we have seen the office, the note sheet.
Yes.
Note sheet, all the other communications were issued to you in the same way. The subsequent communications issued to you.
Yes, yes. Your lordship is correct. In fact, even with my,
You check the note sheet and there is a page 55.
that's my,
Uh, Page 55, we have put the flag here on the right side. And first, check the note sheet, green, those legal size papers, note sheets. See the chronology. There's 4 pages chronology, see the chronology, what was sent. And the communications issued to the incumbent are marked in, are in red ink.
Yes, ma'am.
Red ink, similar nature. Memo numbers are given 9 copies, so 9 numbers to all concerned, including the delinquent. And see the flag at page 55.
Right.
Page 55. See the reference. Turn over the page 56. His signature.
That very case, my lord, the
He had not participated knowingly, but that will not mean that you are not required to hold an inquiry. You just saw the inquiry part. What was the proceeding? We have not been able to detect that.
Okay. No, no, it took it.
Now, in the writ petition, he has made a very clear case that after the initial reply, he was not aware anything. Simply the disciplinary, the final order had come of 2-7. That is removal. Penalty of dismissal. That is the projected case. Now we see that at least one on 20, that 16-6 he replied. Now, this was the inquiry proceeding.
It's with the, it is in the affidavit, my lord, affidavit no koi.
The proceeding recorded by the inquiry officer
My lord.
in the original file.
That's fine. Deepak कैसे है? हाँ.
Report. Where is the proceeding?
Proceeding is not that there. The only
Signing.
indication of this, the report was prepared.
List of records. Chakraborty. Mr. Sharma, even if we give you all the benefits re- uh, of doubt regarding the period when you were actually sustaining or suffering, we leave that period aside.
Yes.
Even for the period after your joining, there is nothing on record
Yes.
that you were serving. In fact, there is an admission. We have seen the inquiry report. He has fairly stated that you were in the meantime given work in the store section where it is light duty.
Yes.
But even there, after one day, you had not, you have,
That
you
is,
did,
that
did
is what
not,
I understand from their pleadings.
did not come.
Yes.
No, I think this appears to be
No, if this
something
is-
very acceptable
Yes.
because just see, it's not, it's a very neutral kind of a approach.
Yes.
I'll just. We are not on the aspects of medical certificate. They did not
Yes. Yes.
submit the originals.
Yes.
You may be at fault. It may be lost by them. We are not on the
Yes.
inquiry about the allergy absentee
Yes.
from the records. He never see him in the work sites or in any adjacent schemes. Allergy absentee was first posted at Katigora, and then he was to work in store section, but he never attended. None of the person know him in person, which is unusual. And you just one part. We have found another part. On examination, revealed that, that the person is actually used to be in service prior to 1/8/1996. And on one occasion, he was seen in the office when he came for a prayer for light duty, which was allowed and asked to attend store section, for watch and ward duty, but he never came thereafter. Plea of his submission of original medical certificate also false, as he used to submit Xerox copies of them. Even several letters were asking him to submit original ones, which he never complied. Leave aside
Yes. Yes.
this aspect.
Then it is never served.
And you reply to 2016. All the letters were issued to you by registered post TD. See, they have done what is possible,
Yes,
humanly possible.
Yes. Yes. So in fact, if your lordship, I completely agree with your lordship observation. If my authorities have done what they could, if I did not attend, then I'm walking on very thin ice. My submission at this point now is subject to the developments here, your lordship. Is that I was 51 when the writ petition was prepared. The writ petition, your lordship, the show cause was served on in 2014. And the penalty which was imposed was from 1/8/1996. As bona fide as the conduct might be, your lordship, the penalty imposition retrospectively from that point might seem belated at this point in time, your lordship.
Penalty from
1/8/1996. That is, your lordship, is at page 62. 62.
no, we have
63 is the operative part.
perusal of the so-and-so,
Yes.
consider dismissed from service for unauthorized absence.
Yes.
Whichever from 1/8/1996.
Yes.
96 to you have got something till it was when was it? Till 99 you were on leave,
I was on leave till 99.
and 16/7 you said that you rejoined.
Yes. That was what my submission based on my client instructions were in this writ petition. Now the records indicate something else. But my submission, your lordship, besides
So
the
what difference in the final outcome it will?
the final outcome is, your lordship, if the date of my last presence in the office was deemed to be 30th of July 1996, and if I had already defaulted from being absent in the office for that long a period, the aspect of initiation of departmental proceeding in 2014, after 18 years, that is a ground of challenge which I seek to invoke before this court, your lordship. Otherwise,
There's no limitation as such. There's no limitation as such. Your employee-employee relation is not severed. It's not related. What outcome, difference in outcome will it make? Whether you are being, have
No.
to be in unauthorized from 1/8/96,
So going forward, if my services are terminated prospectively,
uh,
at least till 2014,
then
then
you're
it-
still unauthorized absence. What will you get?
yes.
What will you get? If you get anything, tell us.
No, the thing is, if I was unauthorizedly absent from office, which is apparent from the record, the authorities sat over it for 18 years. Not because,
No, we have,
primarily because-
we have considered that when we are not accepting that.
Yes.
But tell us, will it make any difference if your dismissal is given prospective effect?
at least then again, no work, no pay is an aspect that will
You
come.
get anything.
Yes.
If it makes some difference, we might have
Yes.
pondered.
Our submission was based on what the client had stated before us, and
Yeah,
now
that's okay.
I'll not dispute with the findings of the report.
That is okay. Who also, your wife?
No,
children?
no, Your Lordship, I'm unmarried.
Okay, unmarried.
My brothers, I have.
What do they do?
Your Lordship, 2 brothers and 3 sisters.
What do they do?
Your Lordship, I'll not aware of it. One brother is a frequent.
And interesting one, ages. Okay.
What do they do other than litigations?
No, the other litigations were by the.
No, other than
Now
litigations.
deceased. The other.
Other than litigations, what do they do?
This seems to
Anything
be.
else or only litigations?
This seems to be the only inclusion in the litigation. Otherwise,
14.
it was only
Okay.
the petition.
And then the ages are also matter, they have crossed
10 years.
10 years, 9,
They are panchayat members.
46, one is 46, one is
They must be
43.
panchayat members. One is Gaon Panchayat, one is Anchalik Panchayat. Died when? 18.
18 Your Lordship, to 26/4/2018.
All factors are against you. If the widow or children would have come, something would have been different. Okay, we'll close this. You may not get the relief. Judgment ইত্যাদি কোনো save করলো। Heard Sri M. Sharma. Learned Counsel. Also heard Sri D. Gogoi. Learned Standing Counsel PHE, who has produced the original records. Full stop. Hearing is concluded. Judgment is reserved.
All right.
Okay,
Okay, any matters where today it will not be possible? Interim orders till today,
Item number 22, there is an interim order play.
22. 22. Any matters interim order till today? Other dates will be given by court master.
Item number 22 will be taken up next week. Your Lordship.
He'll give dates. We'll extend the interim order. Interim order extend for a date. He'll give dates.
Sure.
What is the urgency?
My lord, there was a correction for releasing of the amount, my lord. It was in the year 2008, my lord.
Amount relating
the
to?
incident. Relating to, my lord, victim compensation, my lord. That person has been, my lord, killed by an extremist.
He'll give a date.
Placement.